These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
Session 2, Law is Contract. Alrighty. We're going to start on sovereignty and authority. I'm going to give you a little bit definition of sovereignty and authority and a little bit of input from Jack and Gordon, and then I'll give you my story and personal experience that demonstrated to me the reality and took it beyond principles and concepts. Sovereignty. Supremacy of authority or rule as exercised by a sovereign or sovereign state. Royal rank, authority or power. Complete independence and self-government. A territory existing as an independent state. Authority. A power or right delegated or given. Delegated or given. Does anyone just have authority over you? It must be granted and conveyed. Persons having the legal power to make and enforce law. What is legal?
It's form.
By law, by contract, by agreement. So again, person having power through agreement to make and enforce the contract is how you can read that.
Legal is what exists in their domain. Lawful is what exists in God's creation.
It's also termed that a principal distinction is to be noted or observed between lawful and legal. The former indicates substance and the latter form.
Alrighty. Now, I'm going to tell you about a little experience I had. Was it last weekend? Maybe the weekend before? It's all blocked. I had an emotional experience as well as a physical experience. Either last weekend or the week before, I went camping. And whenever I go to commune with nature, the purpose for me is for spiritual growth. That's what I'm seeking. So I went to the Angeles National Forest and decided I was going to do some camping. Okay? I've never had spiritual growth. And spiritual growth, when you're seeking, be careful what you ask for. I will tell you that. Because I wasn't expecting it to come in the form that it came. It's interesting because every time I do these little outings for myself, I'm always expecting like a lightning bolt's going to strike and I have a spiritual awakening, while I'm meditating on a rock by a river and by a tree or something. It didn't quite come in that form, but it came. And one situation led to another, and I was presented with an opportunity. And immediately, fear set in for me. Do I really know what I know? Am I sovereign? Am I a creditor? Can I take responsibility? And the fear, when I became aware that the fear was there, I realized that the opportunity was presenting itself for my spiritual growth. And so I took responsibility. And as a result of taking responsibility, I granted and conveyed some authority to individuals who consider themselves authorities. I was arrested, handcuffed, and hauled off to jail. Now,
no good deed goes unpunished.
That's true. So, I also, now, because of that fear, I was hesitant to take responsibility. And the fear was always there throughout this entire experience. Fear of different things. Like at one point, I was afraid I might die because of the extreme nature of this experience. Okay, so I realize that contract is dynamic. It is fluid. So even though I had granted and conveyed authority to these authorities, once I was brought to the jail for this particular county that I was arrested in, and a transition occurred where I went from being under the authority of the United States Forest Service to being under the authority of the Kern County Sheriff's Department. And in this process, now that I was under the sheriffs, I decided, I wasn't going to grant and convey to them any authority as easily as I had to the Forest Service.
I think they need to understand that when he says he granted authority, that he identified himself as Brandon Adams to the Forestry Service, who took him into custody after he granted that jurisdiction. They then took him down to the Kern County Sheriff's Office. At that point, he decided a new set of authorities attempting to take over, and he's not going to grant that same authority, i.e., give a name or identify himself as Brandon Adams.
Or grant and convey any interest in any property or whatsoever.
Including a picture and fingerprints. That's what he's speaking of. Grant and convey authority in his property.
Yes.
This piece of property, this body is his property.
It's not me. It's just something I have paramount security interest in. Okay?
So in a technical sense, you don't want them to book you.
Yes. Because booking is a ledgering of an asset as surety for the charges. And I was more than willing to give them a surety, it just wasn't going to be my body. So.
Brandon, get to the bottom line. Start the fire or not?
Did I start the fire or not? I did not start any fires.
Remember, they wanted to book Brandon, or anybody else that comes in needs to be booked, or actually it's defined, one of its definitions under book is to charge with a legal offense.
Remember
Precise.
also, all the courts are admiralty maritime in form. What is the first thing that an admiralty maritime court needs in order to get jurisdiction over the case? Don't they have to seize the vessel and pull it into port to be having subject matter and territorial jurisdiction? And so it just so happens your straw man is the vessel. They want to tow it into court. They want you to voluntarily surrender it by giving the name. And once they got the vessel tied up in the port, they've got subject matter jurisdiction to go ahead in this case. Now that the vessel is there, what you can do is you can go in and you can put a bond into the court in lieu of the collateral of the vessel being tied up, and they may then release the vessel, but then the bond sits there as the nexus to the court to grant the jurisdiction of the case in its place. So the booking is actually surrendering the vessel and tying it up at the port so that they've got jurisdiction to open a public court proceedings. So if you don't book, they haven't tied up a vessel by which they can proceed.
First encounter. Nice young lady working behind the counter at the sheriff's department slides me a piece of paper and tells me, "This is for blah, blah, blah." I don't even remember what she said it was for. I pick it up. I'm open. I pick it up and I start reading it. She says, "Oh, you don't have to read it. It's just for this. Just sign it." I look up at her and I go, "Ma'am, I'm an expert in contract law. You won't mind if I read this before I sign it, will you?" She kind of looks at me strange and grabs the paper. She wouldn't let me read it or sign it. Okay. Clearly they didn't need my signature on that piece of paper. So they then proceed to escort me into a nice little cell. It's like a holding cell.
Hang on one second here, Brandon. Remember what we talked about this morning? What is the currency? Your energy. And what conveys the currency to them? So why are they tying up this vessel? To get jurisdiction, but as collateral against the charges in this case, right? So when your no nature or signature goes down on the document, what have you just done? You have created the currency by which to set off and close this case. That's what they're looking for. But at that stage of the game, see, we're going to talk about it more this weekend. We're not going to take away from this story, but every contract starts out with 2 contracts because you need 2 or more witnesses. They cannot get a contract from you with only 1 signature. Your first no nature is a contract which you're going to sign on the right-hand side as the creditor, which conveys the currency to the corporation, which is the collateral on the case. The second signature is going to be on the left side as the debtor, in which case the currency that you gave them on the private side, they're going to use that currency privately, and they're going to put you in prison and raise a bond on Wall Street where you're the borrower in order to pay the contract once again on the public side, which you are now as a debtor, and you got to go to jail until Wall Street makes enough money on this thing to pay you back so you can get out. So that first contract is the left side offering where you're creating the currency in order to settle this account. Go ahead.
So I sit in this cell for maybe an hour and a half, and then they start, I guess it's a process there. It's very much like a processing plant. As soon as you've got this cell full, okay, now we're going to start filing people out of here and into booking. So they take us 4 at a time into the booking room. I'm sitting in the booking room with 3 other individuals. Mind you, the definition of individual is a bankruptcy estate. I'm sitting there with these other bankruptcy estates, and they call the name Adams. Now, I can only presume they're referring to the bankruptcy estate for which I am the trustee for. And I proceed to inform them that I will not be availing myself to your services today.
So are you saying that when they called out Adams, that's what you responded with?
That's what I responded with. The booking officer looks at me and he goes, "What?" I said, "I will not be availing myself to your services today." He stands up in a very menacing manner. And he says, "Get up!" And I sit there, my hands folded in my lap, very calm, very collected. And I say, "By what authority?" He's giving me an order, a command. I want to know under what authority and agreement I granted and conveyed to him the authority to order me around. He then proceeds to physically remove me from the chair, bounce me into a wall a couple of times, twist my arm behind my back, and as we walk down the hall, he proceeds to bump me into the wall, I'm not sure, maybe he couldn't walk, and he was kind of using me as balance to keep himself from falling against the wall. And then he rams me into a door. I don't know, maybe that's how they open doors there. And when it didn't open, he kind of pulls me back, opens the door, and then throws me into this cell. A suite, as you will, because I had it all to myself. I assumed they didn't want me infecting the rest of the population with what I was speaking about. So I lay down on the bench, very comfortable. I got my sweatshirt on, my thermal on, so it's probably like 70, 60 degrees in there, so it's not real warm, and I get cold real easy. I don't have a whole lot of insulation, so to speak. So I'm sitting there, and about every 20 or 30 minutes, a deputy comes in. And they proceed to make the offer. "Are you ready to give us fingerprints and a photograph?" I respond, "I conditionally accept your offer to grant and convey to you a security interest in my property upon the condition that you present a bona fide claim and or consideration."
Did you do this every time they came to the door?
Every time they came to the door.
So you didn't leave any time they came and asked anything? You never left anything unoffered?
Nope.
Unresponded to?
Never left anything unresponded to. However, very often they did leave they either had 2 responses. "What?" or "Leave." So, about an hour and a half, 2 hours of this, and the head contracting officer for this jail walks in. He's a sergeant. And the sergeant proceeds to make the same offer. I give him the same conditional acceptance. He's maybe a little sharper than the rest because he asks the question, "What kind of consideration?" I'm thinking, oh, he's ready to pay up. So I say, $10,000 should be sufficient, calculating in my head what I think bail might be. $10,000 should be sufficient. He proceeds to shout out some profanities and slam the door. I'm like, okay, was that an acceptance? I wasn't sure. Because the profanities he screamed out were very intimate in nature. So, I wasn't sure if it was an acceptance or a counteroffer, but he proceeds to slam the door. Another hour and a half go by with deputies coming in about every 20 minutes, making the same offer. At one point, a female deputy who, unlike the rest of the deputies who I had experienced my contracting with at this point, she was not coming from a place of ego.
Were there other females or just the first female?
There were other females, but this particular one, when she came in, I saw a look of fear and concern and confusion in her eyes. Okay? So she makes the offer. I give her the same conditional acceptance, except I follow it up with a couple of questions. Because I see the look of confusion on her face when I make the offer, or the counteroffer. And I say to her, do you know what a security interest is? And she goes, no. I go, do you have a title on your car?
Before we go a little further, let's do Webster's Law has a really nice little definition for security interest. A lien on personal property created by an agreement. So when he's talking about a security interest, he's talking about a lien on this piece of personal property right here, the body.
Created by an agreement. And I said to them,
either expressly or tacitly.
And remember, my conditional acceptance was, I conditionally accept your offer to grant and convey to you a security interest in my property.
That's his body.
Upon the condition that you present a bona fide claim. And everyone know what a bona fide claim is? A sworn statement that someone's been damaged, or consideration.
It's in good faith, without fraud, deceit, or deception. No such thing can be brought by anybody that you haven't damaged.
Okay. So I asked her if she had a title to her car. And she said, well, yeah. I said, okay. That is like a security interest in the car. I said, would you give that title to your car to someone without consideration? And she says, well, no. I said, so you understand where I'm coming from. She goes, but your fingerprints and picture aren't your property. And I say, really? Whose property is it? And she kind of looks down and she's thinking about it. Yeah, if it isn't his property, whose property is it? Right? So she walks out of the room. A couple more deputies do the same thing. Sergeant comes in, and we have a little back and forth. He proceeds to ask me. Now, this is where, if someone were to ask me, what would you do differently? I would have left this part out. And I would have responded differently. See, at this point, I'm feeling pretty confident. I'm feeling like I'm controlling this whole situation. These guys can't do nothing. Right? So there's a little bit of ego coming out on me.
No.
And ego is always... Yes, believe it. And now, remember this, because ego will always be met with ego. Okay? And he says, who do you think you are? I said, well, who do you think I am? He says, I'll hold you here indefinitely. I said, really? I said, you think you can hold me more than 72 hours? He said, oh, yeah. I said, we'll see. That was the ego.
That's a creditor for you.
So, then he comes back with 3 very large, menacing-looking deputies. And you could tell he needed 3. Look at me, I'm huge. I'm dangerous. And these 3 deputies are standing behind him, and he proceeds to inform me or make another offer. He says, this is your last chance. Are you going to give us fingerprints? And notice how each time they're asking me, are you going to give? So I conditionally accept. Okay, you want me to give you something. Well, I don't just perform business transactions without consideration. You want me to give you something? I expect something in return. So that's why I keep coming back at them with a conditional acceptance. So he goes, this is your last chance.
So again, you didn't leave everything you heard you looked at as an offer to you.
Yes.
Your last
Everything
chance,
was an offer.
this, that.
Everything.
Everything was an offer.
Everything was an offer.
Okay.
So, and he even followed it up. He said, this is your last chance. Are you going to give us fingerprints and a picture? And I proceeded to conditionally accept his offer. I conditionally accept your offer. I will grant and convey to you a security interest in my property upon the condition that you present a bona fide claim and or consideration. He proceeds to make a motion to his 3 menacing guards, and they're coming at me. And now I would have made a contract at this point, but they're moving fast. And I don't think I could have got the words out fast enough. But I didn't want to give the impression. Because remember, what's more important than the words? Actions and conduct. So I had my hands folded in my lap. I'm sitting down. I close my eyes and bow my head. I did not want to give them the impression that I was in any way physically going to resist, defend, fight in any way. And these 3 guards proceed to grab me, throw me on the floor, throw me into the wall. They're bouncing me all over the place. And I just kind of go limp. You know, I don't, if they have me, I stand of my own strength. But these guys were doing things that I couldn't even stand with. But everything that they did, I always let my muscles loose. I never pulled away. I never resisted. I let them do whatever they were going to do. I was a rag doll. And these guys were just slamming me into walls. They put me in an arm bar that hurt so bad I thought they were going to break my arm. And they escort me up the stairs. They bring me to another cell. You know, they're giving me, I guess this is part of the tour. They bring me to this other cell. It's just concrete. You know, nowhere for me to sit and lay. They throw me on the ground while one deputy stands on my legs with all his weight. He's probably about 220. The other one strips off my clothes, my shoes, my socks. And in this room, not quite as comfortable an environment as the other room. Not only was there nowhere to sit, but it was about 40 degrees in this room. And they took my clothes, the things that were keeping me so nice and warm and comfy. So I'm sitting in this room, 40 degrees. Every moment was pain. It was literally like counting every single breath in and every breath out, trying to keep myself warm. Every breath out, I was breathing on my chest, trying to keep some kind of warmth to my core. Now, I didn't realize this till after the entire experience of being in this room, that I was in this room for 6 hours. I thought, I must have been unconscious for most of the time, because to me it seemed like maybe 2 hours. And especially when all I'm doing is breathing. It's like, it's like counting breaths. That's what I was experiencing. And at one point, near the end of this 6 hours, my hands and arms are completely numb. My feet and legs are completely numb. My face, my nose, my ears. And I'm sitting there just trying to keep warmth, you know, holding my hands against my ears, breathing on my chest, trying to keep my chest warm. About every hour, the 2 deputies who physically did what they did to get me in there and, you know, strip my clothes and everything, they're coming in, joking, you know, making fun and making the offer. And I was conditionally accepting it each time. I wasn't going to go into dishonor. Okay? So, at the end of the 6 hours, I'm really afraid at this point. Really afraid. Because I feel like my lungs are making that noise, you know, when you're sick. And it feels like there's something in your lungs and it makes a noise like your lungs are sticking together or something's happening inside your lungs. And they tell me this, they make another offer about it being my last chance. I'm like, oh, I already had one of those. And so this is my last chance. If I don't give them pictures and a fingerprint, they're going to keep me in this cell till 8 a.m. And like I said, I think I've only been in there for 2 hours. So to me, it's like, maybe 9 p.m.? And I'm thinking, there's no way I can survive 12 more hours in this room. I will die. Like, I was convinced. At this point, I was afraid for my life. Really afraid for my life. And so, I know the definition of insanity. You do the same thing over and over and expect different results, you're insane. So I knew I couldn't conditionally accept in the way that I had been. I couldn't use the same words. So, in my head, I'm thinking, okay, they're not that bright. If I just change the words up, maybe I can get out of here. It's about self-preservation. I still want to be in honor. I still want to be in control of the contract. But I also want to get the hell out of this room. So I'm like, I got to make it sound, I got to word this offer in such a way that they feel the green light to go ahead and take me out of this room, give me my clothes back, and take me to the booking room. Okay? Or at least take me to another room, somewhere besides this freezing room, and give me my clothes. Or at least maybe throw me my jacket, something. So I basically word it in such a way that I say, I conditionally accept your offer to grant and convey to you a security interest in my property upon the condition that you provide a bona fide claim and or consideration. However, if you, without my consent and against my will, without me volunteering, take from me my property, I will in no way physically resist. I will not fight. I will not defend. It will cost you. At this point now I'm saying, I'm not giving them an amount because I'm not sure the damages yet. For all I know, I'm going to have to amputate my arms and I'm going to have pneumonia, so I'm not sure how much I'm going to charge them. I just let them know it's going to cost you. So they kind of look at each other and they look at that as the green light to go ahead and take me down to booking. Now, if I'd have left it at that point, I think I would have had problems, because the contract happened up here in this room. They're in agreement because they stayed silent and they grabbed me and escorted me out of the room. So I can only assume that means that they're in agreement with my counteroffer. They acquiesced. So they take me down to the booking room. Now, when we enter the booking room, I see this as an opportunity to make sure that everyone in that room is conscious and aware of the nature of the contract that's about to transpire. So I say, I am hereby giving notice, because there were two officers in there that weren't upstairs when I made the original offer. So I wanted to make sure everyone in the room, because the officers I made the deal with, they weren't the ones trying to take my fingerprint and picture. Interestingly enough, one of the officers was that young lady that I had had that connection with. And she's looking down at her desk, looks like she's about to cry. Like really having trouble with whatever's going on, or maybe it's something personal, maybe it had nothing to do with what was happening, but she looked distraught. I say, I'm hereby giving notice that I am not granting or conveying any interest in any property. I am here under threat, duress, and coercion. These officers have threatened my well-being, welfare, and life. I look over at the booking officer. I say, I will not give you my fingerprints and picture. However, if you choose to take them, I will not pull away. I will not physically resist. It will cost you. He proceeds to grab my hand and do the fingerprinting and take my picture. Then off to the cell with the general population. Monday, this is all Sunday. This is basically from 2 p.m. Sunday till about 2 a.m. This was about a 12-hour experience. So, Monday, pretty uneventful. Hanging with my cellmates, talking a little shit, watching TV. Not much else to do. I mean, in this particular jail, you're not allowed outside the cell ever. You're in the cell 24 hours a day. You never leave the cell. You got a bathroom in the cell, you got a shower in the cell, you got tables to eat at in your bunks. There's about 12 people per cell. Okay? I'm hanging out, we're having fun, talking. And Tuesday, they're calling everyone who gets to see the judge. They got to get me in front of a judge, right? They got charges. So, I get called. And I am really looking forward to seeing the judge at this point. After dealing with all the belligerents I had dealt with, I'm like, finally, somebody who gets contract. You know, he's going to get it. If no one else gets it, I've been in front of plenty of judges. I know they know contract. I know this. I've experienced it firsthand. I had total faith that when I got in front of that judge, I was going to settle this account. That was my intent. So I'm looking forward to this because this I felt was going to be that test. I didn't realize I had just been going through the test. I thought maybe this was going to be my contracting test. My contracting test had already happened. They take me down with about 60 other inmates into this room. Now, the jail right next door to the court. Very convenient. And me and 60 other roommates are all sitting there in shackles, you know, with the hands strapped to your stomach, feet chained together and everything. And I proceeded to sit in this room from about 11 a.m. to about 6 p.m. Okay? Every single person in that room gets called to go see the judge, except for me. After that, they took me upstairs, deshackled me, and cut me loose. What happened? They did not have a surety for their charges. If they were to take me into that court with an open account with no surety, who's liable for the charges? Someone is. It ain't me, because they don't have a surety. So somebody communicated to someone, and they decided, you better let this guy out, get him away from us, because don't bring him into my court. I imagine the sergeant probably kept a detailed record of what was going on and what I was saying. And if a DA or a judge saw that, okay, this guy was conditionally accepting, contracting, remained in control of the contract, then it would have been clear to them. We don't want this. We don't want a guy in shackles controlling the courtroom. That might give off the wrong impression. So instead, they just cut me loose. All charges dropped, 2 felonies and a misdemeanor. And I walked.
At what point in time did you get your clothes back?
Before they put me in general pop. Actually, no. They gave me my clothes back before booking, but then after booking, they took all my clothes and gave me a nice gray jumpsuit. And like some Cambodian slippers or something. So. I think it was because they never voluntarily got a surety through the booking process.
Remember, contracts are express or implied. The express or manifest, viva voce, that's by the voice or by writing. So they asked him to sign coming in. He wouldn't give his name, so he didn't do an express contract. But there's implied contracts which are shown by silence, by acts, or by signs. So if they just said, get over here and get your fingerprint, hand me your hand, or just get over here and they grabbed it and put it up, his act walking over there is a contract. And it's important for you to understand what constitutes a contract. Actions, again, like Jack told you, Brandon told you, actions speak louder than words. So yes, words can make a contract, writing can form a contract, and your actions can form a contract by silence. You Brandon Adams? Great. He's Brandon Adams because he was silent, right? Silence forms a contract. Acts form a contract. Brandon Adams, get over here for a fingerprint. He walks over, he must be Brandon Adams. So his act indicated that. Give me your hand. He make a sign, he put it up. So be careful. Understanding a contract's important. So that's why we recommended you get some Williston, restatement second, something on explaining contracts so that you really begin to understand. Not as most people tell you that means a meeting of the minds and consideration given. Because if he hands you or walks over, are you presuming that consideration means something of value traded? Or does consider also mean to think about it, and then when you walked over, that's the consideration? You really want to know? You already do. Excuse me. And remember, Adam Bryan, in colloquial speech, people often talk of signing a contract. Strictly speaking, this is inaccurate terminology. The contract is a legal relationship between the parties, and the document that is signed is actually the record or memorial of that contract.
Is merely.
Merely, nothing but. So when you flash around, I've got a contract, here's my rental agreement, there's my contract. No, it isn't. That's merely a record. Because when you went in, you talked to the rental agent. How much to rent the apartment? $900 a month. Can't have pets, can't do this. Okay, that's what I agree to. Here, sign this. That's just a reminder or a record to record what you all agreed to. So down the road, if you get into a legal situation, you have a reminder. But why would you go in and tell the judge, that's my contract? That's a record of what we agreed to, Judge. But this goes to just a quick example. A gal that did a divorce proceeding up in the Bay Area. She moved in with this guy 11 years previous and became married, as the layperson understands, legally 3.5 years ago. And when I took over the case, the attorney she had followed California state law. Nothing she could do. She says, I've been making more money than him. I have to pay him spousal maintenance. I have to do this. I have to pay these bills. He gets the home because it hasn't gone up in value in 3.5 years. There's a lot of equity in it, but none of it since we've been married. I says, well, when did you get married? She said 3.5 years ago. I said, let me ask again. When did you get married? When do you think you were married? Were you married when you moved in 11 years ago? What is a piece of paper or a legal marriage? Again, form, just a piece of paper. So when I called the husband's attorney to try and settle the matter and work it out softly, attorney says, California law says this, this, and this. I says, absolutely correct. California contract says that. I says, are you familiar with it in colloquial speech? Blah, 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 blah. She's listening. And I said, Article 1, Section 10, Clause 1 of the Constitution protects my client's rights. She got married 11 years ago. And when she got married, she owned half the house because he said she owned half the house. I don't care that he only put it in her name like 3 years ago. That's not the issue. I said, now my client wants to do this, this, and this. And if we're not going to do it easily, because she doesn't want to be paying all these bills and doing all this, I said, we'll just simply take half of our property, which is the house, and a few other things. And I was a little, not quite as gentle about it, but very matter of fact about it. I'll take your client's house, take his whole house and everything else with it. And I'll shove his bills down his throat. So, we can do this any way you'd like. She's got, why didn't you say so? I said, I tried to do it softly first, but you don't seem to understand. She said, let me get back with you. I said, I really appreciate that. Call back, says, you got a deal. It was done. Because what is a contract? She entered into that marriage 11 years ago. Legal forms have got nothing to do with it. It was merely a record or reminder. That's all it is. A verbal contract is every bit as enforceable as what people term as a written contract. Although a written one can be construed as a contract also. It has its place. But anyway. So, we have some questions? And we have a bunch of hands over here. Yes, Gordon.
Thank you, Brandon. Thank you for sharing that story with us. I'm sorry you had to go through all that, but I'm glad things worked out in the end. If you feel comfortable sharing with us, could you, when you replay this in your mind, especially the initial altercation when you apparently gave your name, is there anything that you would have done differently? And if you had done something differently, do you think you would have never ended up in the sheriff's or the county sheriff's office?
The thing is, there were some other people there that I did not. If I'd acted the creditor and started contracting with the Forest Service officers, they'd have focused their attention on some other individuals that I did not wish to see in that situation, because I don't believe that they'd have been able to handle themselves in the same way.
So they only took you in?
They took one other individual in as well.
Thank you.
So Brandon could have conducted himself as a sovereign in the very beginning, and highly unlikely the Forestry Service had been able to do a thing to him, and it would have never gone to that. However, as a sovereign, he jumps in, I'll take all the responsibility for this deal here, because they says, somebody's going to take responsibility here, and our hero stood up and says, I'll take responsibility. Here's some ID. Here's who I am.
God bless you, Brandon. Thank you.
Brandon. Question, with all what the police did to you, why didn't they just say, you did offer your fingerprints and stuff? Why didn't they just lie?
Well, because what happens in the booking room is most likely recorded, and there were 4 individuals in there. And I imagine when you start challenging people, like let's say I had brought this to a claim in a court, watch how quickly those individuals turn against each other. You know,
they all understand, just like in a certain retailer, when you have 3 or 4 people you've spoken with, they're never going to match up their lies. They're just human. They're just not going to.
Yeah.
You're not going to get 4 people generally to tell over such a minor, 2 felony counts and a misdemeanor, such minor stuff. It's just minor. It's all minor. Mm-hmm. There was more questions
Brendan,
over here.
Hi.
I had a question.
Hold on.
There's no word to say. There's no word to say how moving your story is, and to hear everything we heard. We think you went through emotionally and physically and everything. And as you know me, I'm always more interested in the spiritual side of everything. Since you were going camping for a spiritual experience, can you please tell me, honestly, because you said you did get your experience.
I did.
So can you please tell me what you got on the spiritual level? What was your experience with everything they had you go through? And including, as in all my spiritual studies before, the deepest fear that we have is to die, is the fear of dying. And I know you went through it. Can you please elaborate on that?
What I got from this experience spiritually, I went from having an understanding of the principles and concepts of being the authority, the author of my life, the sovereign, to actually being that, not beyond a principle, beyond a concept. I had my trial by fire. It tested my faith. It tested my courage. It tested my knowledge. It tested my will. It tested my resolve. It tested my composure. And I passed. Thank you.
You will pay to play.
So that's why I had to
one
share
way or
this.
another.
These things, they don't come without a price. I'm not saying everyone's going to be tested like this, but be ready for it. Do you have the strength, the courage, the will, the faith to stand in the fire, to hold your own, to remain in control, to remain the author and sovereign? Because it may take a lot more than fancy paperwork to get yourself out of any situation. And I want to mention that there was no paperwork involved. There were no tax forms. There were no GSA forms. It was purely contract, oral, verbal.
Do you have a question?
my actions, my conduct. That's how I remained in control of the contract. And something else, I walked out of there like, holy shit.
No,
I'm unstoppable!
And no toilet tissue.
Is that it? Oh, thank you. Thank you.
Yeah. I had a question about the situation with the married couple.
Yes.
Hold on, we're losing.
Hello. Oh, she claimed that they were married 11 years ago, but he claimed he had a paper saying that they were married 3.5 years ago. How did anybody determine that it was actually 11 years ago?
The opposing attorney understood that they had moved in together 11 years ago. There wasn't any question in anybody's mind about that. The question was, what was her understanding of the agreement? Was she married? And her understanding was she had married 11 years previously. She only legalized it 3.5 years ago. So if you were to take that understanding and be able to enforce that claim, then it would change the dynamics of what's going to happen in that divorce entirely. Not reference, what's that? Well, he doesn't mind arguing, but his attorney understood law very, very well. And I was able to articulate in a reasonable tone that, I think we're going to take the house. And if when you deal with people that are rather shrewd and sharp in business, they're really, just like Brandon told you, get in front of a judge, you're going to be dealing with a contract expert. Anytime you deal with quality attorneys, which there are many of them, they understand contracts very, very well. They do this all day long. Doesn't mean they get a play in our field administratively the way they do. They're bound by a certain set of rules and stuck with them. So, however, in this situation, that attorney understood, and as I did, I don't care what California state law is. Got nothing to do with the game. Matter of fact, if I was her and I'd moved in a month before, wouldn't matter. If I say half that house is mine, and I moved in and I thought half that house was mine, half that house is mine. I thought a chess set was mine too, didn't I? Diane?
I got two questions. Didn't he accept a benefit when he put on the gray jumpsuit? And two, how much is it going to cost him?
I do not charge my brothers. They gained from this experience as much as I did spiritually. You should have seen the looks on their faces when I was walking out of there. I think they're going to... I believe that if I did charge them, that it would give them something else to focus on other than who they were being spiritually, The
process isn't for where I might lean up somebody for $40,000 for a $10 plastic chess set. It wasn't malicious. It wasn't to harm him. I was doing it out of a different kind of a situation. He was acting the same way, out of a different situation other than revenge or to gain something. I was doing it for a particular reason also. It had nothing to do with the monetary gain and revenge. It was just business. It really wasn't personal at all. He did not take what happened to him personal. There's nothing personal about it. It was just business. And he loved his brother enough. In that case, the benefit from his viewpoint was not to charge him or penalize him. Because they may have taken a picture from one viewpoint, but another viewpoint they did not take the picture because they didn't use it in court. Had they used it in court, there might have been another whole dynamic altered here where he says, it's $250,000, but he feels he's going to get in front of a judge to do that.
Yeah, at that point I felt, the contracting skills of the deputies I had met up until that point were none. So I didn't feel I was, the benefit was that we had a contract at that point. They understood it was going to cost them, so I played the part. Like, okay, I'll be a slave for 48 hours. You know, that's the contract. They agreed to it, that it was going to cost them, so I played my part of the contract. I didn't want to be in dishonor. They took something from me by force, and so I played the part for 48 hours. Now, I don't want to say messed with them, but whenever they would call my name or something like that, because it's funny because it's clear to me what they're doing when you're in there is they have to constantly reestablish authority and jurisdiction. So they would do things like just come to your cell and call your name to get you to respond, like they think you might have just disappeared. You know what I mean? Like there's any way I'm just going to disappear from the cell. They would come in, Adams! And I would look up and say, I may be able to help you.
He's got a point. You know, the same thing in prison when I was there. They come beat on the cell door when I was in a county jail, and they say, Hall. I just ignore them. Pretty soon they knock on the door. I say, yes, can I help you? Same thing. We're not responding to the name, and he in that case was simply, how can I help you? That's English with a slight pause, had a comma in his sentence. How can I help you? Inferring that I'm not he, Adams.
When you were sharing your testimony, your story, it reminded me of what Yeshua did for us. And it felt very much like that, how you faced that fear like he did in the Garden of Gethsemane and kind of like went to face death if need be. But a debtor and that's an attorney says, what's wrong with suing them? We said it will cost you. What's wrong with saying to them, you violated my civil rights? You caused me pain and suffering.
I want them to feel it at a spiritual level. I feel if I do charge them, it'll give them something else to focus on. Because what will happen is all of their bonds will be surety for my charges. And they'll all lose their jobs. And you know what? I've seen the people they deal with. I was in a cell with a guy who was in there for attempted murder. It's not like everyone in jail's a nice guy. None of us have done anything. We're all here. No, they're all there by agreement. But some of them are dangerous. They're harmful to our society. And it's not, and it's best that people like that don't understand the contractual nature of things. So I don't blame them because they just saw me as another one of those types of people. I was a danger. I feel that they wanted the fingerprint and picture so bad because they thought I was some kind of super criminal. They thought clearly we got one. He won't give us the fingerprint and picture. He must be really in trouble. We're going to find him in the FBI database, and we're going to find him in that database, and we're going to be able to keep him in here. We're going to be the good guys. We're going to be the heroes because we caught the notorious Brandon Adams. Right? So again, I don't blame them. They were doing their jobs. I walked out of there completely fine. Like my lungs were messed up for maybe a week.
Is that like a father forgive them? They don't know.
Exactly. They don't know what they're doing. They don't know it's contract. It's not like they're like, we're going to dishonor this guy the whole way. Screw his contract. They don't get it. They really don't get it. Like, that's why I was anxious to see the judge, because the judge does get it. These guys didn't get it. I knew that when the sergeant, the one who would be the most competent in contract, yelled profanities and slammed a door on a conditional acceptance. Like, that's pretty clear to me. They don't get it. So I wouldn't feel right about charging them for this, because I already come from a place of not charging my brother. Because it's not, in reality, like I said, it wouldn't be this, it's not like it would reform the system. It's 10 guys would lose their jobs. And I don't want to, are we not already losing enough jobs? Do we need 10 more guys to lose their jobs? The funny thing is, hold on, I'll get to that. You can give him a mic so that he can repeat it. I didn't mention this, but the next day, after the first night back in my own bed, I woke up and I cried. I wept. And it wasn't because of what I went through. It was for them. It was for where they were at spiritually, that they were able to conduct themselves in that way with a person like me that never resisted, that never gave them any physical sign that they needed to treat me this way. I was a gentleman. I was calm. I was collected. And how it must weigh on their souls now to find out, oh, the notorious Brandon Adams has actually never done anything and isn't in the database. And here we physically abused him for 8 hours. You know, that's got to weigh heavy on their souls, not to mention how many people they have to do this to on a daily basis. Like, this can't be a healthy job. Spiritually, it cannot be a healthy job. So I cried for them. I felt so bad that this was what they do on a daily basis.
You know, two things. Number one, since they never had a valid booking, notice what happened to the court case.
Oh, I didn't tell you. My brother and dad finally found out Tuesday morning where I was. Everyone's like, "Where's Brandon at?" And they found out on Tuesday morning. My brother was monitoring the case online.
Mm-hmm. Okay.
And he said it went from having, you know, the case number, the charges, an arraignment date, and a trial date, okay? And the arraignment date was for that day, Tuesday. So my dad and brother, they pretty much know, don't bail him out or anything. You're just going to screw up his contract. But they were kind of anxious to see, okay, how's Brandon going to handle it? Because they're watching the case. And my brother says it went from having the arraignment date went from the actual day of Tuesday to pending. Then the trial date went from a date to pending. Then it went to none, and then gone. So I'm thinking at a certain point something was communicated because they were planning on having an arraignment, but something convinced them otherwise.
Well, there's other good news. They did not transfer you to Getmo.
That is
and
good
they
news.
did not waterboard you.
They did not waterboard me.
Good sign.
Brandon, I'd like to compliment you first and foremost, having been in a similar...
Louder.
First and foremost, I'd like to compliment you on that and tell you, be careful with the ego on this, that you've won yet. The nightmares are still coming. I still have them from having been tortured and done this. I did not do as well as you did, but when you're having your own government beating you, drugging you, torturing you, it gets a little more intense over a 6-week period. But similar enough to know that the act of forgiveness does change them, and it really would. I mean, I was ready to sneak back into that camp and kill them all when I got away. But something inside kept me from doing that, which probably is one of the only reasons I'm sane today. The next thing, on the points you're speaking of, as you, Jack, would recommend movies, Paper Chase would be perfect to convey. Most lawyers don't understand contracts, but those who do grab it, and they emphasize in law school, contracts are important. They're important, but they know they don't want most of them to know because they know most of them are incompetent. And if a lawyer doesn't, your average cop doesn't. But there are some who are waking up, and you can have fun with them, and they enjoy it. Like you say, they enjoy having someone who's awake to deal with. It changes that view, like what the three of you are helping us to recognize. Start playing with them. We can wake them up too. They are so bored, and they want someone to interact with them as a human being, and then they can be a human being. It'll catch on. I think you guys are doing great on that level. Thanks.
Alrighty, we now have another story to share where sovereignty wasn't quite maintained.
have a friend, and he said one of his buddies went into a traffic court in a western state. The judge called the name of the case, and this gentleman stood up and said, "I'm a sovereign." I don't know why you guys are laughing at him. The judge just kind of decided it was a different day, and we're just going to go with that theory, okay? And so he said, "Well, come on in." And of course, the gentleman didn't even know, even as a sovereign, who he claims he was, how to go into the bar and still reserve any rights. So he went into the bar, and the judge said, "Okay, sir, you're a sovereign, right?" And the gentleman said, "Yes, that's true." He says, "Okay," he said, "we're going to go with that today." And the prosecutor or the clerk looked at the judge like, what's he, flipped or something? And they said, "Judge, you might want to reconsider that." And the judge goes, No, this man says he's a sovereign. He says, "I know what I'm doing." So he said to this gentleman, "Here's what I need to have you do for me. Before 24 hours tomorrow, I want you to come in, and I want you to bring in 3 documents and give them to my clerk. I want you to bring in your birth certificate. I want you to bring in your Social Security card. And I want you to bring in your driver's license and just give it to the clerk." And this guy is looking at the judge like, this isn't exactly what I thought was going to happen here. What the hell is going on? And the judge said, "You can go." And again, the prosecutor and the clerk were looking at this judge like, "You aren't setting any kind of strange pattern here, are you?" And the judge goes, No, sir, you're all set. You're done today. Get out of here." And then the judge proceeded with the other cases. Now, the following day, this man decided, I don't know what the judge is doing here, but maybe I better follow the judge's lead. So he brought in his birth certificate, his Social Security card, and his driver's license, and he gave it to the judge's clerk. And the judge's clerk said, "Very good, sir, you may go." And he said, "Well, wait a minute." He said, "What's going on here?" I have no idea. I was just told that you were going to come in, or else I would have to tell the judge, and you've done that, so you're out of here. See you around." So he left. About 10 days later, he's in the middle of town. This was not a really big place. And all of a sudden, he gets arrested. And the law enforcement guy that arrested said, "You're going before the judge." And he said, "Well, what did I do?" And the law enforcement officer said, "I don't know. I just had been given instructions to arrest you and bring before the judge's court." So he's brought immediately before the judge in this court. And the judge is kind of smiling and saying, "How are you doing?" And the guy is going, "Well, I don't understand, Your Honor. Why did I get arrested?" And the judge kind of looked at him and said, "Well, what were you doing in the bank?" And the guy said, "Well, I was cashing a check." And the judge said, "Cashing a check? Why were you cashing a check?" And he said, "Well, I need money to eat and live on." And the judge is kind of shaking his head and said, "Sir," he said, "I have your documents here. I'm giving you back your birth certificate, your driver's license, and your Social Security card. Here, Mr. Bailiff, pass them back to this man." And then the judge said, "I am finding you guilty in that traffic case, and your fine is $240. And if you don't have this fine paid within the next 30 days, you'll be in here on a show cause on a contempt. Now get out of here, and if you don't like my decision, you can go appeal it. What just happened? Why did the judge have him surrender his birth certificate, his Social Security card, and his driver's license? Don't they belong to the straw man? And as a sovereign, why does he need the straw man? Who has the account in the bank? The sovereign or the straw man? The straw man. When he went to the bank to cash a check on the public side, is he behaving in the capacity of a sovereign? No. It's not what you say you are, it's your actions. When Brandon was involved in his caper, it doesn't make any difference what he says he is. It's involved in his actions. Does he have rights? Is he reserving those rights? And is he voluntarily becoming a surety on the public side for the straw man? Now, had this sovereign passed the test, then within the 21 days or so, the judge probably would have sent in the documentation and canceled, or basically, what do you do in the military? Discharge, or you surrender, or you decommission the property, which is no longer then dedicated to the military. So this judge said, well, let's just see how this works. In this small community, you don't think the judge wasn't following the acts and actions of this guy like a hawk behind the scenes? Are you sure that he hasn't got connections in the bank and know that the straw man's got accounts there? And when this guy went in to cash a check, you can say to the judge, I am a sovereign, but he doesn't know what a sovereign does and how a sovereign acts. And remember, the clerk of the prosecutor said to the judge, are you sure you know, judge, what you're doing? And he says, yeah, I've seen this before. We're going to give this a try. Now, as far as what the judge explained to this wannabe sovereign in the court, did he tell the wannabe sovereign anything? Or did he just act like a referee and say, I gave you a shot, you blew it, you're found guilty of the charges of the straw man, since you seem to want to act like the straw man, now pay your fine, because we know you can go back to the bank and cash checks, just like the straw man does. Now this guy said, but I have to eat. Do you mean to say as a sovereign you have no commercial energy in order to acquire food and other objects that you need to keep the body alive? Or was this sovereign never trained in how you involve yourself in the world of being able to sustain yourself without getting on the public side of commerce? If he was sovereign, should his bank account have been opened or closed? Closed. If he has a closed bank account, can he still use it? Yes. But he has to use it on the closed side, which is private banking. Haven't you ever heard about private banking before? This sovereign obviously never heard about private banking before. All he knew is how to do public banking as a slave, which is not the same actions as private banking of the so-called sovereign. So the judge just gave him enough rope to hang himself. Let's see how this sovereign operates. Obviously, the guy said he was something that he was not, and the judge never argued with him. As long as he said to the judge, I'm sovereign, the judge said, we're going to go with that theory. Have a nice day. As soon as the guy demonstrated he wasn't a sovereign, the judge goes, not going to argue with you. I've seen the results. This is the response. Have a nice day. All the judge was doing was treating this guy in a mirror image as to the way he went out in society and he operated. He claimed one thing, but his actions were another. It's not what you say you are, it's what you do.
I love judges. They're so great. I've never been in front of a judge, win or lose, that wasn't trying to teach me something. They are masters of contract. You ever find yourself in the wonderful opportunity of being in front of one, pay close attention to every word that comes out of their mouths. Because like I said, win or lose, every time I've been in front of a judge, they've given me gems of wisdom.
Matter of fact, there's no reason you all shouldn't go in front of a judge by going down to a court building and participating in some of the daily activities there. It's an educational experience. An interesting comment that was being taught by the judge at this last hearing I was at with this gentleman that we're dealing with this murder case in Arizona. Prior to his case starting, there were several prisoners from the county jail there, and there was a particular prisoner who was up there handling many matters for all these guys that were there as a jailhouse attorney. And eventually the judge said something to this effect to him. Blah, blah, blah. I'm merely a facilitator here. I think that was directed at my guy just before the case started. I looked at my guy, John. I said, did you get that? He said, man. The judge admitted he's merely a facilitator. It's important to understand it's the prosecutor, Adams over here, and the defendant or charged individual, Hall over here. This is the court. He's merely the ref, the facilitator, to watch you two conduct business. He sends a charge into him. He gives it to me. What am I going to do with it? I better give it back on some conditional acceptance or straight acceptance for set-off settlement and closure. Then I have a claim. But you know what? If I don't give my brother, the prosecutor Adams, what I just did and the certificate of service showing I gave it to him and give that to the judge, the ref is not going to see that I'm playing fair with my brother. Believe it or not, that ref is up there simply watching you two play, just like in a tennis game. Problem is, and we had it asked before, why does the judge keep going? Why do they keep testing us? If we settle the matter, why don't they just settle it? Judge Smith, would you care to attend to that question?
Because the ball's still moving on the court.
Well, why after I have settled this, sent in to the prosecutor and gave it to the judge, set off settlement and closure, does this judge say, well, you need an attorney, Mr. Hall, and you need this, and maybe we better have a Ferretta hearing, and a Rule 11 hearing, and a competency hearing, and what about this, and what about that, all these other offers. Why isn't he being honorable? Judge Smith, could you? No, this is serious because this is a legitimate one. They continue to come at you. What is really happening? And as if you don't understand the rules to the game, it becomes very unsettling when you go into a court. You thought you set aside this, you have your administrative remedy, and this judge is acting like he hasn't seen it, or won't see it, or will ignore you. And he keeps on ignoring you, and you say this and you say that. What was the term you used earlier? Not only do you stop him with some kind of conditional acceptance, but you better activate him, charge him.
Oh, move.
You had a nice word for it.
Call to action.
You better call to action I better call to action this situation, or the judge is going to keep coming at me. Because impliedly, if I'm not going to settle the case, then I must not want to settle it, and he keeps going. But perhaps Judge Smith could enlighten us a little bit. Why does he keep coming at me? I mean, I thought he was an honorable guy, Judge Smith. What are you doing?
Well, which sector is he in, the private or the public? He's honorable in the private sector, but what is the judge in the public sector?
Colorable.
He's colorable, he's a liar, he's a thief, and he's a crook.
Now you say, is that bad or good?
Well,
Since
for the
government does it
public-
right all the time, it's got to be good. Why is it good that he lies, cheats, and steals, or does that? Riffraff's not getting through.
He doesn't want to let the truth out of the bag. Remember, we said everybody that goes into court on a criminal case, what's the first thing the court wants you to do? Enter a plea, right? If everybody entered a guilty plea or a not guilty plea or any plea, what are they? Debtors, and so they have to pay the price. So why do we bother with any hearings? Why do we bother with any trials? Let's just take them out and hang them on the gallows. Because it's done when the plea is entered, right? Well, look, here's what's going on. The court is exactly like gambling in Las Vegas. Nobody can win if they don't want them to. Now, the problem is if everybody went to Las Vegas and everyone went home a loser, who's going to Las Vegas next week? No one. Okay? So, if I told you that everyone that goes into the criminal court, we losing the mic? We may have a battery here. Maybe not. Still green, not coming through very well. Okay, back on again. If everybody goes into a criminal court and enters any kind of plea, and they're taken out the back door and shot, then next week, everybody that shows up in court and they say, how do you plead? They're going to go, oh, well, none of us are going to plead today. It wasn't going well last week. Okay? So in answer to the question, even when you're in honor, why don't they just stop right now, pat you on the back, and send you home? It's the same reason why they don't take you out back after you entered plea and shoot you. It's because the people would say, what did he just do? He got patted on the back and he went home. And everybody would connect your ability to prevail in this court to that immediate action that you just accomplished. And they'll go, look what he did. We're going to do that. But if they keep delaying and delaying and delaying, somebody's going to say, well, I don't know why he got off. I mean, this has been going on for months. And you're going to say, well, it was because of what I did at that first hearing when I didn't enter a plea. And what is your ignorant friends going to say? Well, if that's the case, they should have sent you home right away. It couldn't have been that. It had to be something you did yesterday, and you probably don't even remember what it was. See, from a colorable point of view, two things. They don't want to give you a clue of what it was you did when you did it that caused the end result, because you're just going to go out and say, by ego, hey, I know what it was and this is what you got to do, which in essence is what we're up here trying to teach you. But to expect an immediate result isn't going to happen, because they don't want to reward you for the right thing you did right at that time. It's going to be a delayed reward in the hopes that you still don't understand what you did. Number one. Number two, isn't the legal profession in it for a business to make a revenue in the public system? And if they settled all these cases immediately after arraignment, what are the attorneys going to bill their clients for? You understand? Because criminal and civil court cases are a huge business and revenue for the government and for the attorneys. Now, it depends on how much the attorneys understand this private process. But you understand, by being attorneys, they practice in the public. Shouldn't you have to reward those people quite a bit in order to induce them to stay in the public and keep playing a game in the public in which there really aren't a lot of benefits? The benefits come by understanding the private side and unalienable rights and the trust that was given to you, which was your estate, which is being held on the private side. You're not supposed to know about it, but I'm not so sure that the attorneys, even if they knew, could access that private side trust while at the same time keeping their license and their lucrative profession in the public. So how are we going to keep the legal boys down home on the farm unless we allow them the perks of income from their profession, and their only income can be enhanced by delaying these procedures for motion hearings and trials and hearings by which they have billable hours to their clients? Remember, don't they say that if you are representing yourself, you have a fool for a client? Isn't that what they say? Who is the yourself that you're representing? Who is that? The straw man scarecrow. Does he have a remedy? No. So do you have a fool for a client if you're trying to act like the defendant and get him off the hook? Yes, because there's no remedy for you. However, if you're in court as the authorized representative, who is your client? Nope, it's the Tin Man. He's on the private side. Does the Tin Man have a remedy? Yes, he has access to the asset set-off account to zero the charges in the court. So if you are an authorized representative, you are not, quote, representing yourself, because yourself, the only yourself they can see is the defendant. As an authorized representative, you are an agent for a foreign creditor. And as his agent...
They got to change the tape.
Got a tape change?
No, we got a break.
Break? Okay, we'll do that in a second.
Excuse me.
As the authorized representative, you're not representing yourself, the scarecrow, who has no remedy. You're representing the secured party creditor that has the set-off for the charges. Do you have a fool for a surety that you are the agent of in that case? No, he's got a perfect remedy. And once you bring in your surety, the substance of the proceedings in the public venue are taken care of. But for all the reasons we just mentioned, they want the form of those public proceedings to go on indefinitely so that the rest of the public does not understand what you've done, and to keep testing you to see if you're going to wear down or change your mind. How many times does Brandon have to be bounced off the wall before he surrenders and says, okay, I'll be a slave? 1 time, 50 times, 100 times. He's got to not surrender his rights as long as they keep challenging them. As George Gordon used to say, if it's important enough for them to keep coming against me, it's important enough for me to be responding. Whether it's 1 time, 50 times, or 1,000 times. We will test that theory. Who is more determined to protect my rights? Myself or them challenging them? If you surrender on the 541st time, then the original 540 times are moot. You should have just surrendered to begin with. You will be tested. The question is, will you be what Scripture calls an overcomer, or will you surrender to the public testing?
And with that question, let's take a 30-minute break, come back here and finish up on contracts and trusts.
Contracts are fluid, they're dynamic, they move. I had some comments early referencing contracts. We're not as good as Brandon, be able to hold our mud, so to speak. Can you get a second chance? Well, obviously you do. Understand, they're dynamic and fluid. That means they move. Brandon made a contract with the Forestry Service, didn't he? He says, I'm a slave, I'm a debtor, I'm a Brandon Adams. Take me away. And they did. He gets to the sheriff's station. He decides he doesn't want to be there anymore. He don't want to be a debtor anymore. So they say, Mr. Adams. It's not him he's talking to, and that's when some party starts and maybe a little aggression because he's kind of being a little double-minded, but it's all right. So at any time of the game, you can get yourself back on track. If you make mistakes, it's okay. You can fix them. Most often for a long time. And even if you end up in jail, you can fix them. But you're just getting started when they attempt to pull you off the street, then they attempt to book you. They still got to get a plea agreement out of you. They got to bring charges. There's all sorts of opportunity to fix. So for y'all that think you just get one chance, not at all. You get lots of chances. And when you make a mistake in court, such as a couple of the students that I have that went into court, they're way down in the process, they've done their administrative proceeding, they're in a particular what's known as a FRERETA hearing, a mental competency hearing, 1 hour and 35 minutes. It was about 20 minutes into it is when they took their left foot and shoved it in their mouth and screwed up royally, executed in open court some paperwork, and did their signature even. It's crazy. They just gave it up. The next hour of that hearing was technically a waste. Judge had them. When they figured it out, they called and they said, oh my gosh, we're ruined. I says, really? Why don't we just, fix it? Within 3 days, they fixed it. It was back into the court. We're right back on the track over here. So you're going to get lots of things. You don't have to be so nervous if you make a little mistake. Party over. Not so. Not at all. It's okay. And if you don't have respect for a 900-pound gorilla, you're out of your mind. You're going to be nervous. You're going to be fearful. Here's Mr. Expert. Did he tell you he was fearful? He was choking. Of course he was fearful. He's not dumb. Nothing's done until it's done. Of course, his faith in his ability is, of course, about way up here, where it was only here, and yours might be down here. But precept on precept, you're going to get it. Little trial and errors. Don't be jumping off into, hey, let's try a ticket deal right out of the chute. I'm going to warn you, don't do it. Policeman pulls you over and says you're doing 82. Don't say, and? Gordon said it. Well, why can't we? Well, you better know what you're doing. So try little stuff. Practice the little stuff. You're going to be I'm at the bank. I told you I'm at the bank. I'm on the phone, and I've dropped a check in to be deposited, and I always put deposit for credit or exchange for non-redeemable Federal Reserve notes, or just exchange for Federal Reserve notes on the back of the check and hand it to them. No problem. Then all of a sudden I'm on the phone, and I got 3 teller ladies behind there looking at the check and talking. I said, I better go. I think I might have a problem here. I says, is there a problem, ladies? And, well, we'd like to know why you wrote this on the back of the check. I says, is there a problem? No, we're just curious. I says, well, am I not depositing it for credit or exchanging it for Federal Reserve notes? Okay. Thank you, ladies. Have a nice day. Last week, and that one happened like 3 or 4 weeks ago. Last week, I'm in there again, standard stuff, doing my thing, and then a different teller gal I hadn't seen before. She says, you know, she sets it aside, she does her other stuff, and just before I get ready, she goes, oh, could you sign this? I says, well, why would I want to sign that? She just smiles at me, takes the check, and have a nice day. She knew something. They talked to her about it and said, see if you can get him to sign it. When he comes in again, I'm in there all the time, but this time, try it again. Contracts are dynamic and fluid, because what I wanted to do 3 weeks ago got nothing last week. What Brandon wanted to do with the Forestry Service 30 minutes ago has got nothing to do with what he wants to do there. If I was in jail, and if I happened to have given my name and a fingerprint and a picture, that doesn't mean when I go in the courtroom, I'm not going to decide, I don't want to play this game anymore. I don't want to be a debtor. I'm going to come back with something else. I'm going to make the contract move, because I know that contracts are dynamic. They move. You're the one that makes them move. And why does the government always go silent for you? Because they're there to help you. That's why. So they're there to help you move your contract, if you know how. And we have some people say, we were talking earlier about they just keep on doing and coming and coming. Well, my contention also, in conjunction with what Jack told you, is, like Brandon said, I told you when I was in court, judge says, hey, I think you might need an attorney before you hurt yourself, Mr. Hall. Are you telling me I can't resolve this matter, Judge, without an attorney receiving public benefits? He says, no. It's what Brandon said. Call to action. I'd already settled it, but I wasn't sharp enough back then to say, well, then this matter's settled. Is this court not ready to adjourn and submit this matter under law, contract, to an issue of an order to discharge the defendant and discharge the United States claims? I needed a call to action. Stopping him isn't going to do it. I conditionally accept upon proof of a bona fide claim. I need to call to action and make things move. It's my court. So relax about this game. Don't worry. What I'm trying to tell you is we've got some stories from people that'll be told during this one that have tried some of this stuff. And I'm talking on eviction notices and some wild stuff in court. And Ray will be one of them that we're going to hear from. He got a great story. There's some other ones. Brandy had a great one that he told about 8 of us down here. It's a beautiful thing to know that that judge is a ref. He's not going to bite your head off. Once you get the game down, you're going to have some fun. You're not going to, and you're going to be nervous and sick and almost throw up and all sorts of things if you don't have it come out of a hearing and throw up, because some of you have. Because it's gut-wrenching. It's okay. Relax. Have a little fun. Just because Brandon seems like he's way up here and Jack's way over here, that doesn't mean anything. You all, if you will put some time and effort into this, in 2 to 6 months, you're going to become very proficient at this. It's not so esoteric that you can't grasp it. It's just new. That's all it is. It's not difficult. It's just new. We'll be going over some of the simple arithmetic basics, 1, 2, 3 step that constitutes coming to a administrative procedure that allows you to establish a claim, that allows you to get some things done. Or in Brandon's case, they couldn't get a claim on him. He didn't give them a name to open an account to establish some pecuniary damages, monetary damages, because it's all monetary. Because that's the way the system works today. We won't get into that at this moment. But for your benefit and edification, know this. Relax. And don't rush out just because Brandon did that. Don't feel like you're not sovereign because the neighbor's getting busted for 10 pounds of cocaine in his driveway. You don't step and say, that's mine. I'll take care of that. I might be sovereign, but I'm leaving the neighbor on his own on that. I don't think I'd interfere in his stuff. However, if he stashed it on the side of my house, I'm perfectly content dealing with the matter. The issue isn't what's the cocaine doing. The issue is what are you doing trespassing on my property? Some of you have heard the one about, so Lieutenant, tell me, were your men trespassing or poaching when they found the body of the dead peasant girl? That's the issue. So you're going to get good at this. Just persist in some studies. Attend some seminars. All that stuff's free on the Creditors in Commerce site. You can listen to it. And it's going to seem a little Greek. It's okay. As you get used to it and you hear Brandy's story and Ray's story and Brandon's story and Jack's story and Gordon's story, pretty soon lights are going to start going on and circuits are going to connect and you're going, God, I can do this. Yes, you can. It's not that big of a deal. All I do is say the same stuff over and over again all the time. And because it's Greek, it's a little difficult. But once you start getting into the swing of this, you're going to say, man, you're going to be a pro at it, and it won't take you long. Juanita's starting to do a bunch of stuff. It's real nerve-wracking for her because she's new at it. But you talk to her, I watch, in about 30 or 40 days, she's going to be saying, well, what, don't you know? Come on. And you'll be the same if you will persist. But you're not going to get there if you put just 1 or 2 hours a week. I'm not saying you got to devote 10 hours a day, but a couple, 2, 3, 4 hours a day, at least 3, 4 days a week to get your rocket ship off the ground, to have some breakthroughs mentally. And then you're going to understand that contracts are dynamic. They're implied and expressed. Unilateral, bilateral. These are all kind of maybe strange comments to some of you, and others you know perfectly what it means. Single and double and this and that. And this is where I've told you simply, what do you need for study materials? Get a Webster's Fourth Collegiate. Go pick it up at Borders or one of those. Will set you back $20 some odd. A Black's Fourth, Fifth, or Sixth, and maybe an Eighth. As a Man Thinketh by James Allen Free on the internet, and a little contract book. Every day, spend just a little time learning 1 or 2 new words. Brandon said, what did he say? He's talking about a transaction of a security interest. Get a dictionary and understand security interest, because that's a big one we use in a lot of things. It's really not very many, but because you haven't heard them or understand what the words mean, it seems daunting or difficult. When, you know what? It won't be. Ray had some neat breakthrough. Brandy had some neat breakthrough. And as you start compiling some principles of contracts, and as I've said before, out of this 1906 set of law books I'd gotten in prison one time, the one paragraph that stuck with me that was worth the whole set was, almost the whole procedure of human life implies, or rather is, the continual fulfillment of contracts. Go look up the word fulfillment, continual, contracts, etc. And you go, God, it is. For you to be here, for him to be here, for us to be here, we all made contracts. All of you that are in personal relationships, whether it's husband and wife, mother, father, son, daughter, you name it. Those are all contracts and relationships. It's all contracts and agreements. Once you get it through your mind and through your conscious, you're going to just move really rapidly through a succession of vicissitudes that will give you a learning curve that will just be exponential. And in 2 to 6 months, you can expect to be able to handle a lot, if not most of all your business, not only professionally, but paperwork-wise. On Brandon's site, you've got all this. If you get a frivolous letter from the IRS, you don't have to come up with some conditional acceptance that you spent years studying. This guy put together a beautiful one. Use it. And of course, Jack, he's got all this stuff on his Monday night downloads. It's free to you for years. Listen to it. It's off the charts. The guy is just a genius. These guys are like bright. They're on top of their game. But you don't have to spend years and years to get it. You can get the handling of your life, which is contracts in my opinion, in 2 to 6 months without busting your hump more than a reasonable college course. And in a year, 2 years, you're going to be way off the charts if you put some real effort into it. And especially as you start working to help your friends. And as you begin to teach others, you're really going to move through some learning curve. And as you hear Ray's story and Brandy's story and Brandon's story and this guy's and Gordon's and that and Jack's, and you're going to start seeing the commonalities that are there. They're going to give you some real belief and faith that you can do it. Because you know what? It's just like roller skating. It isn't much more difficult than that. It's just Greek to you. So a little persistence, a little patience, and a lot of study, and you'll be there in no time. 2 to 6 months is not much. 3-4 hours, 3-4 days a week, you're going to arrive there. And if you just do 1 or 2 new words a day, 7 to 14 words a week, just 1 new word a day, pick it up out of the dictionary, take 2 minutes to open it, honor, dishonor, creditor, debtor, security interest, just some law word, nunc pro tunc, pro se, pro per, impropria, prosign, just some new word. Your mind will start moving and shifting quickly. And all these buzzwords are just going to be common words to you that are uncommon to you today. So let me turn the rest of the time to these guys and let's get moving. And
all righty. Actually, I think what we haven't, we did dynamic and fluid nature. Implied, I want to express contract pretty straightforward. An express contract is clear, either verbally or in writing or in any other way that there is a contract in place. Implied can take so many forms, and really most contracts come are in an implied form. Implied can be your conduct in particular conditions in a situation, can imply silence itself. So there's so many ways to look at this. I suggest getting any one of the contract books that we've discussed, and each of them will have a section on each of these terms up here. You know, the unilateral nature of a contract, that could be, I'm just giving you something and you accept it. No performance on your behalf is expected. That's a unilateral contract. Bilateral contract is I give you something, but I expect something in return. The reason I put intent to contract, most would think that there must exist an intent to contract in order to contract. And I want to read you, if I could find it real quick. I saw a beautiful quote in my commercial law book by Williston on intent to contract. I'll read it to you. Because it's funny because I had never seen this until last night. I just happened to be browsing my book here. Here it is. Intention, as we ordinarily understand the term, plays little part in the law of contracts. In order to create a contract, it is not at all necessary that the parties possess an intention to assume a legal obligation.
intention isn't what you ordinarily thought it was.
Isn't that amazing? So now you know that when the offer, give us your fingerprints, I don't have to have any intention in contracting in order to be caught up in a contract.
Your intent will be manifest by your actions. You walk over and give it to him, you clearly intended. It's said thusly. Motive is determined and or evaluated objectively. I don't care what you thought about it. I'm just going to look and see what you did. Act.
Absolutely. And then, of course, we've covered offer and acceptance, which creates mutual assent. So acceptance could be something as simple as silence. I make the offer. Or acceptance could be in your conduct. Acceptance could be in your performance. Stand up, and you stand up. That's an acceptance. You don't have to say, I accept, and then stand up. So keep that in mind. And counteroffer, which we discussed, like a conditional acceptance is a counteroffer, and it does what?
Conditional acceptance is always a counteroffer, and it's a statement by the offeree which has the legal effect of rejecting the offer and proposing a new offer to the offerer. I'm the he's, Jack, give me that pen. That's an offer to him. I offered him to give me his pen. Policeman says, give me your license. He just wants to know if you have one. All of those things. The policeman says this. The judge says, sit down. I had a friend go into court. Comes into court and he says, standing outside the gallery, judge calls, clerk or judge calls the case. He says, I'm here as so-and-so, secured party creditor, private trustee for the purpose of helping the party settle all claims or charges outstanding. The judge goes, what? He goes, I'm here. And judge goes, just come in. He went in. Judge just said, I didn't hear what you said. Just get your ass in here. Is that what he said? I don't know. Do you have ears that can hear? He said, what? He just said, I didn't hear you. Just come in. My friend stepped in. Then the judge said, now go sit down next to your attorney. He went over and sat next to this attorney. I said, what are you doing? He's still in jail. It's over a year later. It's really interesting. It doesn't take much. And would one little mistake stepping into the bar do it? In that case, no. We had another one of our students up in back east. Did a beautiful job on one case. Then they set it off to another court. He goes to that court. Arrives there a little early. And at this particular place, there's a clerk's office outside the courtroom. Clerk says, who are you? He says, well, I'm so-and-so. He says, I have an 8:30 appointment. She says, just sit down. So he sits down. That didn't hurt anything. That little faux pas wasn't a big deal. He didn't say, I'm the intervener or anything. Clerk just said, sit down. That didn't hurt him. At 9:40, she says, okay, go on in. And he walks in in the court doors, walks in, and there's the judge up there, clerks, and there's an attorney in there for the bank. Attorney's going like this, come on. And so he walks right into the bar. And the attorney says, so-and-so here for so-and-so bank, blah, blah. And this is so-and-so. And Tony, just go have a seat over there. He allowed himself to be introduced as the defendant. He went over and sat down. He just made a contract to be the defendant. Then he did a really good job in going when he was defending not defending, but when he was asserting his rights in the courtroom and going back and forth on the matter. And the judge told him, this is just a lot of phony hooey and blah, blah, blah. And this particular guy called me, is very upset. Man, I was just in court, Gordon. I just got blew out. He says, I know that it's something, they always do it right, so I must have done something, but he didn't believe it for a minute that he was at fault. The next day, he called me and he goes, man, I blew that. Because he's doing so good, and he's a very talented guy. He just got nervous. And there's nothing wrong with being nervous and binding up. But then he turned right around and fixed it again. So you do get more second chances. You don't get bound up. Even though he totally screwed that one up, the judge blew him out. They ruled against him. He put in for another hearing and got another one. It was within 3 days. So you get lots of chances, but contracts the intent is manifest by what you do. And that's why the court sometimes is going to say things that don't make any sense to you at all. In this particular, we'll go on a little bit further, move this along, but you'll hear where they say things that don't make any sense, but you end up getting what you came there for, like an abatement of proceedings. I've had that happen on at least 3 or 4 of the cases, federal and state, one on the murder, on the others, and a couple other cases. My clients are always getting their extensions. But that isn't what the court said. Oh, we're busy, we're too tired, we got this going. We're just going to put this matter off for 60 days. Or, legal research, blah, 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 blah. And we're going to put it off 60 days because these people said that. They're sure not going to honor your deal. Yes, they are. And we don't care what they say because motive is determined objectively. I don't care what they say. I want to know what they did. Did they give us the time to do our administrative proceeding? Yes, they did. Brandon?
Absolutely. So also keep in mind, outside, because not everyone here, hopefully not everyone here is dealing with court issues. But keep in mind, even an offer, let's say from the IRS, in the form of a notice, your lack of response creates a contract, an agreement with what they've sent you.
You hit court.
Anything that comes in, any offer, if it's a form of a notice, especially a form of a notice, and any lack of response thereto constitutes agreement or acquiescence with the terms of that offer. Even in your personal relationships. I think some of you had heard my story about when my ex used to talk about things and I didn't respond because I didn't want to oppose her opinion and create some kind of conflict, so I would just sit there in silence. And then we'd be out somewhere in public and she'd say, "He agrees." And I would immediately go, "What? I didn't agree." But I had, by remaining silent. Little did I know she was such an expert in contract law. So keep that in mind. It happens everywhere, in everything you do. Contracts are created. When you sit down at the restaurant and order from the menu, there's a contract.
Brandon said a minute ago, hopefully a lot of you are not in court. I contend probably almost all of you are in court right now. What's court?
Legal relationship.
Court's really important to understand. It was a comment I read out of a case. It said, in common parlance, going to court is synonymous with going to trial. When the IRS is sending you letters, when Visa is and the bank is sending you a credit card bill, you're in court. Rest assured, you are in court. When you might end up in what's a public court with the black robe judge up there, you're in a trial court, an appellate court, if you will. The court record from below, which was the paperwork going back and forth, and most all of you are in that right now. In some kind of a mortgage situation, credit card situation, some other issue, or you want to be in some other kind of an issue, or you have some problem to resolve, and it's going to require court. Private court or public court, but you're going to be in court. Try not to misunderstand that you better conform with procedure. Do you have a mic? No. Blow into it. There you go.
Under offer and acceptance, where does seal and consideration fit in? That's the coin, isn't it?
You're talking about whether there's consideration again. You have to get that out of your mind that there has to be what a layperson might think of. I didn't get anything for consideration. If you considered and you moved your bunnies over there against the wall to get a picture, you gave consideration as far as the law is concerned. You're in, babe.
I learned in business law 40 years ago under the principle versus Baxendale, offer and acceptance, seal and consideration. Now maybe that's going by the books. I don't know.
No, are we looking at contracts as they apply to the document, the memorialization of a legal agreement? Wouldn't that be under seal? Is that what you're referring to?
I don't know. I'm just posing a question because that's what I learned, and I'm just asking if it's relevant today.
It is. It's very relevant. Learn it. And in that book that I just picked up and read from, There's an entire section on sealed contract. So learn it, understand it, and then really think about how to interpret it, because it might not necessarily be saying what you think it is saying. Be very conscious. Look up every word, because words don't necessarily mean what you think they mean.
And we talked to, before you start, Richard,
Inconceivable.
I always talk to a lot of my students, and I'm using the word moot. And pretty soon I'm getting emails back, M-U-T-E. I said, no, the agreement's not mute, it's moot. And when you start looking up words, you'll get a real understanding. Yeah, an agreement is not silent, it's moot. Richard, what?
Okay. Being many of us, at least myself, are in a situation where
keep the mic in one place.
Where what we've done is we've dishonored by not responding to things because of whatever circumstance. Would you address, I heard you do a little bit on another thing, I don't remember what it all was, but address it because I know others need it. How do we reset the contract in motion so we can get back in tune with those offers they've given us?
How do you reset back in motion? Something depends on where you're at. Let's say that the bank, I have some of the students, the bank sent you a notice a month and a half ago, and you didn't answer it. Well, I
or IRS, yes.
IRS, I like to put let's say I had something that the IRS sent me from call it August 1st, and all of a sudden here it is October, and I'm going, boy, I've been a little bit remiss in my duties. Well, why don't I just date it August 3rd, and in parenthesis, either under the date or next to the date, I'll put nunc pro tunc, now for then, and send it back, which is a counteroffer. Which is, I'm dating it then, now for then. How about that? They can say something, but what are they going to do with it usually? They're going to agree, aren't they? Well, of course, well, it depends. If the IRS said, hi, how you doing? Here's a check. No, I'm going to cash the check. If the IRS is saying, you owe me $563,000, well, then I'm going to do me an acceptance for value. Nunc pro tunc that baby, and I'm going to fire it back. And in a few days, since they're going to agree with me, we're going to be in business. The IRS kind of moves along at a little bit slow pace. They're not real rapid. They're there to try and help you get some remedy. I've never seen them just move rapid fire, machine gun fire on most of us. It's usually lots of letters and over time and take a year, 2 years. They give you all sorts of time to fix things. Most always. There'll be some exceptions to the rule. I'm sure there's some out there. However, even if you screw something up, remember, contracts are dynamic and fluid. How long did he wait? Unless he made a deal with the Forestry Service, and on the way down, he must have changed his mind and decided he didn't want to do this anymore. All the heat's off his friends, don't need to do it anymore. Didn't take him long. He didn't have an agreement with the sheriff's office anyway, not about to give one. But he had one with the sheriff's office cousin, the Forestry Service. They're a little miffed at him. So they might have been a little bit less than courteous to him. But that's okay. You got to ask him, and was it worth it? You remember, he asked God for the epiphany. God said, okay, well, you're not getting it all these other ways, Brandon. So why don't we give you a little fun? And, of course, I asked for some wisdom and knowledge. 9 years later, I'm like, okay. And, of course, Deepak heard about that, and he said, hell, God, I'd like some wisdom and knowledge. No jail time, no negative adversary. He put some qualifiers on it. He's a little smarter than I was. Did you ask for some qualifiers? Did you say help, God?
I didn't ask for any qualifiers.
I was
looking for spiritual enlightenment.
So God gave him what he needed. And look at how his attitude is. He says he's empowered. Now, can you all expect some kind of rough play from these guys? No, that's the first I'd heard of it. But I didn't know that he'd ask God for a little help. He should have said so. He got what he needed. You better be careful what you ask for, because you're going to get it. Yes. Better get a mic. Come on, Deepak, quit fooling around. We just blew his head all up. He's just that way.
Yeah.
I wish I created that kind of town. He's good at what he does.
I was just curious, I was curious what the most core components are that have to be in place for a contract to happen. I mean, does it have to have two living souls to be a contract? Can a living soul contract with an inanimate object? Can I have a contract with my corpus and my body?
Yes, you can have a contract with your God. You can have a contract with anything. You can have a contract with yourself. You could say, I am an empowered man, and I live my life this way. That is a contract that you have with yourself. And you're either going to be in breach of your contract with yourself, and you can even put qualifiers on it. If I don't live my life this way, then this. And watch how things just magically align with your contract. Watch how what you ask for is what you get.
The aphorism, as a man thinketh in his heart, so is he, not only embraces the whole of a man's being, but is so comprehensive as to reach out to every condition and circumstance of his life. A man is literally what he thinks, his character being the complete sum of all his thoughts. What the mind harbors, the body manifests.
A little bit of a practical question. You guys are telling us that we have to respond to everything that is sent to us, and very often...
Whoa. I didn't say you have to do anything. You could be in dishonor all day long.
If you want to be in honor, you have to respond to everything that's
You're going to go through one of those four doors. You're going to accept, you're going to conditionally accept, you're going to go silent, or you're going to argue with every offer that comes your way. Whether it's a basket of fruit set on your doorstep, whether it's an IRS letter, a Visa bill, a call from me to you, Boyan, it doesn't matter. If I telephone you up and you don't return my call, that was a response, wasn't it? I might not like it because you didn't return my call. But it's nonetheless a response. And you have your choice to do whatever you will with every offer in your life. Now, if you want problems, just ignore those offers from the 900-pound gorilla. Now, of course, the 300-pound gorilla, like the bank, they might simply get a judgment against you and seize some money out of your bank account or lien your home or something, as opposed to giving you some time away from public in the private penal system to rethink about what you were doing. Yes?
However, the essence of the question is, I'm communicating to the CEO or the IRS, somebody, and I start getting those letters not signed by anybody, that have nothing to do. They are not they are not a qualifying response for my conditional acceptance of before. What would I do with the things that are not signed by anybody? They seem to have something to do with my communication with the head of the IRS or Mrs.
Recognize it for what it is. It is not a response from the person you made the offer or counteroffer to. Therefore, the person you made the offer or counteroffer to is in agreement. You've now got a data integrity board, a second witness, so to speak, to your agreement. What are you going to do? Are you going to establish the facts?
This is
with that data integrity board or that second witness? I mean, in reality, if you don't have the second witness, do you have a judgment?
This happens with a lot of you with the Visa cards, with the credit cards. You send the CFO an A for V, R for V. Pretty soon, some other department at the bank sends you a letter and says it was frivolous, it's phony, whatever else. We don't understand it. Or they just send you another bill. But a cane didn't come from the CFO. What he's telling you, and Jack will tell you, somebody's got to be a second witness. Well, you conditionally accept your offer to pay again upon proof of claim that the record, parenthesis attached herewith, and grab that record you sent the CFO, shoot it back to that entity that sent it to you, and copy the CFO with your response to that entity. Then you might get a third one out here from Visa card over in Ohio when you've been getting something from Visa card in Sacramento for your card over here in Arizona that you sent to the CFO. And pretty soon you respond to that one and you send that people over here in Sacramento and the CFO what you responded to over here in Ohio. Now you've got a nice record. If I was them, I don't think I'd want to take somebody with that kind of an administrative record or that kind of court record into a trial court or appellate court, because the only thing that's going to be seen is that record, your administrative record. And if you know how to stand on that claim, guess who's going to prevail in that case? Not even a question. It absolutely will be you. But when you get that summons from the Superior Court, the Federal District Court, or whatever court it is, that's an offer. Hey, why don't you come on in and let us decide what we want to do with this thing on the public side? Well, you better answer that without going in there on the court-appointed date. Maybe you want to consider, I'd love to come in and let you decide this case upon condition or in accordance with, or I'll accept it as long as there's any ruling, determination, judgment, etc. therein shall be in accordance with the record, attached, so I got all my whole administrative record, attached, that the record attached herewith or hereto,
and incorporated herein, attached hereto and incorporated herein in its entirety,
of set-off settlement and closure that is accepted has not set off, settled, and closed the matter. Now the judge says, oh, great, I just invited this guy to come in, and he just said he's only coming in if I'll rule in accordance with the damn record he's got. Well, let's see if when I get him in here, if I can get him off that. Come on in. What'd you say? I can't hear you. Just get in here. That's another offer. I'd love to come in, Judge, upon condition that it's as intervener for the purpose of merely helping the party settle all claims or charges, or in accordance with the record and pleadings that were submitted via conditional acceptance of your summons to this court.
And hereby reserving all rights and remedies.
Yeah, and I do that too. How do you want to go in that bar? How do you want to go in? I'd love to come in and talk to you, Judge, let you decide this thing as long as it's in accordance with the record of the lower court. Now, he didn't want to hear that. Now, that brings up some. They do want to hear that. These judges are thrilled when you people start acting like creditors. Believe it or not, they're not mad at you. A democracy ends one way, anarchy. When you come in on the Republic, they love you. Now, we won't go into it right now, but there's a couple of where I've got some stories from other people who have used this. One with a retiring judge who said, after that person had exercised their stuff, this is a phenomenal way for me to retire, and gave this guy remedy. It was beautiful. Because he'd gone in there and acted the sovereign and over again. And real strange stuff, like coming to the court building and they'd have an 8x10 glossy down in the marshals coming in the building. And they go, he's here, he's here. I'm telling you, there's some great stories out there. Some of you all have some wonderful stories. And as we start to share those at some of these, and as you start to hear some of these other things, understand this. Those judges are thrilled to see you people wake up. They are thrilled. Are they going to cut you one iota slack? Hell no. They're going to slice and dice you if they can, because they know how to do and honor their job. Their job is to see to it no riffraff gets through. And it's not. But once you get the handle on it, just like Brandon's, man, he's empowered. He used to think sovereign. He's now sovereign. He's really feeling good because he's been in court I don't know how many times. So he always felt good in getting judged. Now he's had a little fun with the bureaucratic side. And you can rest assured he's going to be so calm and he will exude power when he comes in next time. Because when you know what you're talking about, these policemen, these judges, they are experts at humanity. They can take one look at you and they can smell and see fear. Just like a dog or any other good animal. They can smell it, they can feel it, they can see it. Some of you people that are familiar with dealing with men and women relationships, you can feel when you're dealing with a confident guy or a demure woman or whatever else. You can size somebody up in a lot of ways pretty quickly. Some of it's much harder to get to, but these judges and these policemen who deal with humanity every single day and study it, they can size you up the minute you open your mouth. The minute you step or walk, how you carry yourself. They're going to see it just like that, and they know what they're dealing with. and they know when they're dealing with power. They know when they're dealing with an authority. Absolutely. So if I say to a police officer, and you say, and, it's two different sayings. It really is, believe it or not. And the same goes with a lot of stuff. But as you go precept on precept, you make little mistakes, and you cure them in this, and you go to some court hearings, and you see these judges make these beautiful, I'm just a facilitator. And you'll hear Brandy's comments. I don't know where Brandy is here, but he has some great stories. They're trying to help us, and Brandy didn't do a whole bunch of stuff right. And he got all sorts of remedies. I like his story. We're going to hear it. And Ray's. You're going to hear some great stuff. You can do it. You can be there. And it ain't going to be that much. And you get lots of chances. This game, you're going to start, once you get out of the fear cycle and you start having some fun, you can rest assured next time, he was even kind of excited. I'm going to go down here and do this thing with the police thing. Of course, then when you're in the middle of it, you go, what'd I get myself into? But he pulled through the other side like a champ. What would you trade for that experience?
Nothing.
We said it. What is the value of knowledge and wisdom? More value than all the things thou canst desire. I don't know what the price for you. I feel that my time in prison was such a blessing. I can't believe how lucky I got. And if you understand that all things work together for good to them that love God, no matter what happens to you as you start embarking on this game, and it is a game, the game of life, you're going to play. I promise you, you're going to play. You're going to be a pawn or you're going to be a king on this board. And as a pawn, you're not going to like it because you're nothing but cannon fodder. As the king, everybody's there to protect you. And I'm telling you, these judges love you when you come in and you're honorable. You think they have any more? Well, I don't have the quote, but it's somewhere. I've given it in one of my seminars wherein the quote, and I don't have it on my mind, wherein the Chief Justice said that 75 to 90% of attorneys were either incompetent or some other nasty, disparaging remark. It's a different one than that, but it's a neat saying. The long and the short is they love to see you all come in and be sovereign. They love it. They're bored all day long. They just get debtors and slaves in. That's why they really could sleep on the bench. The decision doesn't matter. They get to do what they want. But in a law court, there's some excitement here. Their day's spiced up. You know how boring that's got to be, go day after day to just sentence their poor brothers and sisters to penal system? You think they like that? Man, that has got to be very discouraging for those fine men and women. You can imagine when you come in, oh, we got us one. You can hear him in the back room. Oh, Brandon, man, you ought to have seen this dude that come in today. Ooh! Or we got a gal over here that's out of Delaware. She's really neat. I can hear those judges now. Man, you should have seen this chick that came in today. She had me, Brandon. She had me. But I got her at the last second. It was good. She fell for the old okey doke. You could see it. I'm telling you, they genuinely love you and like you, and they are really thrilled to see you do it. I'm telling you, they are. You might act mad. Prosecute. I don't know how many clients I tell, oh, he hates me. No, they don't. They love you. You think they don't do their job? I promise you they do. And they love you. But what do you do to children who are undisciplined? They have to be disciplined. That's the rules of the game. And it's not going to do any good. How bad do they got to make it before you're going to have your bunnies into a seminar and start taking the time to learn? I heard about that sovereignty stuff. Isn't that heresy or stupid stuff? I don't know. God, I heard a gal got out of jail, and I heard that guy set off $4.8 million, and a buddy of mine that was in here, $2.8 million. He's got a car company, and the Better Business Bureau's on his case, and the DMV, and we shut those down. And he goes, God, this stuff's so good. Ask him what he thinks of it. Ask others it. Ask him what he thinks of it, or him. These are people that have seen it. Well, ask Ray what he thinks of commercial law and the rules. Well, ask Brandy. Man, I'll tell you, your fellow students, your people are going to tell you, this is the cat's pajamas, man. This is the best thing since sliced bread. It doesn't get better than the game of life i.e. contracts. And those judges are pulling for you with all their heart. And once you get that in your mind, you can go in that courtroom with an understanding they're purely a facilitator, a ref. All that paperwork coming out of this guy over here. Judge might help him, but that's okay. What kind of game would it be if it was easy? It's no fun to play a game that's easy. You bore of it quickly. These judges are anticipating lots of sovereigns coming in and showing up. Man, they're bored out of their gourds. You're going to make their day, because that means there might be hope for America and this society if y'all wake up. If you don't wake up, democracy's in an anarchy. They're not going to have a job easy. Their children, their neighbors, their families, their friends are going to suffer under the yoke of tyranny also. And it's not some amorphous government. You are the government. It's their neighbors that are going to do it to each other. It's the most unbelievable thing on the planet. You have the power as sovereign, as authority, as in the capacity of. This is the game. This is what we've waited for. Never has it seemed so bright or good as it is now. And as Ray or Brandy, any of you that start getting remedy and little deals and tickets go away. Hell, Deepak can tell you some beautiful experiences of his going into court. Beautiful stuff. Is this just happenstance, coincidence, or it slipped through the cracks? Not at all. Those contracts are iron. It is totally, well, that's a loophole. Really? There's nothing else. There's no loophole. It's the law. It's all there is. And Article 1, Section 10, Clause 1 sees to it, and which is the Articles of Incorporation for this federal government, they see to it they protect your right to contract. Every civilized society in this world lives by contracts. There's nothing else. Consent makes the law. Embrace the game. Look forward. Those judges are looking forward to it. If you can just get the paradigm shift in your mind, a model or pattern shift, they like it when you come in. You can be a little bit more brave and not so frightened. And believe me, it's hard. I don't doubt that Brandon still has a little bit of jitters when he goes into court, and he's only been in 24 times or more. Do you still have a little bit of jitters? Or are those completely gone?
Not too much. Sometimes, maybe.
Negligible.
Depends on the judge and what because often I'm sitting there watching to gauge the judge and what type of a person they are. And, some judges, I'm watching them, and if they seem to me to be very honoring of contract, and again, this is just my own personal judgment based on their behavior, I then feel confident when I see one that seems belligerent, and again, that's just my judgment of it. It's not that they don't understand anything any less. That is their method, and I may not feel as comfortable with their method. Like you said, they'll yell at you. Not because they're mad, that's their technique.
They're just trying
it's automatically going to put you in a childlike state when someone yells at you. Can you still hold your own when they yell at you? Because automatically you want to become a child, and you automatically want to give up all your authority. As soon as someone yells at you, you go back to that childhood. And that's just their technique. I love the story with the judge who told him, oh yeah, just, you're sovereign, fine, bring in your birth certificate. And that judge was very confident in his understanding of contract. He's like, okay, I'll play this game.
What are you going to do if a judge doesn't obey this stuff? A show cause order to an appellate court why he shouldn't be removed from office would be his worst nightmare. He knows the law. He knows the whole game is contracts. He's going to comply with them because it's what the game is. And if he thought you had the least amount of understanding of law, he's going to mess with you? I don't think so. Does a warden want to mess with certain people? I don't think so. Most everybody. But once somebody understands commercial law, and every judge does, he's not going to mess with you if he thinks you understand commercial law. Not in the least bit. He knows his duty. He knows his job. He knows his oath of office. And more important, if he thinks you know what you're doing, he knows you can have his bunnies in a world of hurt in about a nanosecond. Go ahead and violate my contract in there when he doesn't have a right to. Might be interesting to see him removed from office. And that's the end of his career. That's only going to happen to him once, to get showed up like that. He'll never make appellate court, in my opinion. Who knows, but I don't think so. And I can't imagine a judge so silly as to let that slip.
Thank you. We've got sound. Okay, great. Thank you. I've done the A for V process, and I'm at a point where I'm getting offers now that I don't know that I should be responding to. What I've already done is I've done the conditional acceptance, the notice of dishonor, the notary presentment of that dishonor, and the certification of that dishonor, as well as a statement of balance at zero. And
you don't know if you should respond?
I've done those as to that company starting in July. And
right, but you're saying you've gotten offers after that and you're not sure.
No, I've gotten no offers to any of those that I've sent. Let me ask the question, and then I'll back up and I'm giving you the backstory first. I'm now getting phone calls from the company, which I don't acknowledge. I also get statements still from that company, one of which I've acknowledged as a conditional acceptance. But now I'm getting offers by email as well as snail mail saying, we see that you're not paying your bill any longer. We would like to offer you a 9.9 interest rate on that and a hardship, blah, 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 blah. But there's no signature at the bottom of any agent doing so. I also got a letter from the CEO of that company, of which I conditionally accepted the offer upon proof of claim that the instrument A for V that I had already sent was not valid. And I've heard nothing from CFO or CEO since.
Well,
they still also have not balanced my account on a statement. So my question is, I just got another statement a while ago. I just got a call saying, you got a statement in the mail. What do you want me to do with it? And I also got another offer for a 9.9 interest rate. You know, do you want to refinance this thing?
Who in the world of commerce and in the world of contract or commercial warfare, who loses the battle?
He who stays silent, I think.
He who leaves the battlefield first.
Okay, so that answers my question. So I conditionally accept everything they keep sending me?
No, absolutely not.
Okay, thank you.
Okay, your question here is the same thing as the statement of that gentleman about a half hour ago. Because he basically said he finished his first process and then he got a communication back from third parties within the company. That's what's happening to you right now. Okay?
Yes.
My question to the group is, what is the difference between a trial court and an appellate court? What is the difference in the functions that they perform? Pardon?
Because it's rhetorical. Answer it.
The trial court deals with the facts. What does the appellate court deal with? The law. Okay? Takes two witnesses to everything. What you're doing is you are negotiating your agreement with the CFO because he's on the private side. Now, maybe even before you're done getting your first letter, your second letter, and your certificate of protest, somebody on the public side of that corporation is already contacting you. Or, after you finished your process with the CFO, somebody on that corporation, or a successor even to that corporation, like a debt collector, is going to be contacting you. Remember the rule that if you leave the field of battle, you lose. So if a third party contacts you, you have to respond to that party. Otherwise, you are admitting whatever they've got in their letter to be stipulated facts. Now, ordinarily, if you go into a trial court and you lose in the trial court, what are you required to do? Appeal. why would you go on an appeal? Well, let's look at the possibilities. If you have not got a record of facts in your trial court, which is correct, there is no reason in going on appeal, because the only record going on appeal is your factual record in the trial court. And if that factual record is not on your side, don't go on appeal, because you cannot change the factual record on appeal. Agreed? So there's no remedy there. You got to go back and you got to get a correct record back at the foundation, which is between you and the CFO. But now the CFO remains perfectly silent and never responds to you at all, correct? What does that tell you with regard to your record? He's in perfect harmony and agreement with you. And the reason you go to a certificate of protest is because it's done by a third party, which is a notary. Since it is done by a third party and a notary under their rules of evidence, that format is an exception to the hearsay rule, so it's admissible in any of their trial court proceedings. Now, I'm stating trial court, but in reality, these are administrative proceedings, but it may as well be like a trial court. Now, what happens is, since you have never had a response from the CFO, you are winning. The problem is you've got to get somebody on the public side to recognize that win and ratify it, to change the corporate records so that the corporate records show that you're set off for that account should be ledgered on their books, and they ought to stop coming after you. But in the trial court, they deal with the facts. What does the trial court do to deal with the law of the case? What does the trial court always do? They find a recommendation of law based on what? The facts as they apply to the jurisdictional venue of the trial court. Well, in the public corporations, what law are they assuming applies to them? Public policy. Does public policy recognize your private set-off?
No.
No. Okay? So they automatically do not accept all of your administrative process in that company, because they do not and cannot see your law which applies to the republic. They assume the law which applies to the democracy. And in the assumption of that law, they do not see your private set-off. So they will ignore you. What do you need to do to get a remedy? You've got to go on appeal and let the appeals court look at the law of the case as it applies to the facts. Because the appellate court can attach the law, and it can see international law, it can see your law, or it can see its own law. Isn't your offer an acceptance back to them based on the law of the republic, the private side?
Yes.
So the appellate court has the capacity to attach a finding pursuant to your law, which the corporation itself cannot and will not do. How many people have done an A for V, R for V for the Internal Revenue Service? Did the Internal Revenue Service, with your A for V, R for V, ever zero and set off that account without going to appeal? Anybody ever had a settlement without going to appeal? One. Interesting. Usually what happens is IRS comes back, they ignore everything you've done, and they send you that letter saying that we intend to levy and lien. Isn't that what they do? When they send you the letter that says we intend to lien and levy, what do they send along with that letter that gives you your rights? They tell you how to request an appellate hearing. On the documentation, you are given two types of appeal. One as of right, one as of privilege. The one as of right, you have to request within 30 days of the date of the notice of lien and levy. If you're 31 days after that date, you are denied that appeal as a right. They tell you you can ask for an appellate hearing anytime. But they tell you that if you ask for the appellate hearing, which is beyond the 30 days, that if they deny your appeal, you do not have the right of judicial review. But they tell you if you ask for the appellate hearing within the 30 days of the notice date on the lien and levy, and you ask for the appeal as of right for that 30 days, within that 30 days, they'll give you that appeal. And they tell you that if they rule against you on that appeal, you have the right then to go to judicial review. In the Bill of Rights, Articles in Amendment to the U.S. Constitution, if the amount in dispute is over $20, do you not have a right for judicial proceedings? Yes. But that is a right, not a privilege. If whatever you've done does not create a claim based on a substantive right, you can't ask for an appellate hearing under the category of a right. What is the difference between a right and a privilege? Doesn't a right have to state a claim? Doesn't a claim have to be centered on a title? If you don't set forth a security interest for a title, you don't have a claim, you don't have a right. When IRS is asking you to settle a case and you use your asset funding, does that create a title and a right? Yes. If you send them in a Federal Reserve note, does that claim a title and a right? No, because a debt doesn't create a title, and a Federal Reserve note is evidence of a debt. So if you're using your private set-off account, you now have a right and you've claimed a title, which means that your appeal should be stated within the 30 days from the date of the notice, not from the date you receive the lien and levy. They will send you the notice of lien and levy 20 days after they dated it, and you're going to get it just before the 30 days. Do not think that you've got a month to wait to ask for this appellate hearing. You've got to go back to the date on the letter, and you've got to ask for the hearing within 30 days of that date. Since you're using your private set-off to settle these claims, you've got a claim, and you've got a right, and you've got to ask for appellate hearing. IRS is the easiest one, because they will tell you right on your rights for appeal, they'll say, if you request an appellate hearing, and if we rule in your favor, we will abate the lien and levy procedure and return to you anything we may have taken. So what do you do when you ask for the appellate hearing? You submit with your request for the appellate hearing your record of the trial in the original court. What was the trial in the original court for Internal Revenue? It was your A letter, your B letter, and your certificate of protest issued against the agent in which you were having the negotiations. Doesn't the certificate of protest evidence that the agent left the field of battle and never responded? So the certificate of protest is the record of your proceedings in the original trial court. The reason that the agent did not abate the lien and levy is because he is the trial administrative, and the trial agent cannot see your foreign law of your set-off coming from the Republic. He cannot acknowledge that. In his job description, he does not have that ability. So you must submit your record to an appellate proceedings. Now, when you request the appeal based on that IRS, are you going to have to go to a physical court hearing? No. This isn't the tax court. This is an administrative appeal. So when you submit it in writing, you authorize them to review the record that you are submitting. Now, as Victoria keeps teaching us, that your record is your CCI of these proceedings. What record does the agent or the government have to show that any of your record is not valid or true?
It's a CCI?
Yeah, commercial, what is a CCI? It's confidential commercial information, okay, which is just another name for your record. Okay, it's on the private side, confidential commercial information. What information did the government submit back to you in your administrative procedure showing you couldn't do this? Sir, did you ever get a letter back from the CFO saying you couldn't do it?
No.
Okay, so what is the record of their CCI in his particular administrative case? It's zero zip. When did the IRS guy ever write back to you and tell you you couldn't use your set-off based on the bond on the back side of your Social Security card to cause a federal income tax account to go away? Did he ever tell you you couldn't do it? No. Where is their record in CCI in opposition to yours? And there's plenty of federal case law that says if the government cannot produce a record in opposition to your record, then we admit that none exists. And if none exists, there's no record to oppose you on appeal. If there's no record to oppose you on appeal, what is the appellate court going to rule on? Number one, the sufficiency of your administrative factual record. Well, did you go to completion on that? Yes. Is there any factual opposition record from the government in opposition to yours on your record? No. So none exists. So what's the only record of fact before the appeal court? Yours. Now the appellate court goes, we got the facts, we got to attach the law. What is the law of this case? Well, if you kept coming back on the private side, and you didn't screw up and move over to the public side, forfeiting your remedy, then the appellate court can say, well, this is submitted under the law of the Republic. It's not submitted under the law of the democracy. And this party is acting in harmony and capacity with one who operates out of the Republic. He's staying in character as a commercial creditor. The appellate court can look at foreign law. And since it sees that your factual process is in harmony with the law of the Republic, do you think in a heartbeat the IRS is going to rule that whatever the IRS, the DTC, and the FRB does on the private side is invalid? Well, hell no. But the appellate court or the appellate review proceedings can see that, whereas the original party cannot rule on that. So the answer is, you've finished your original administrative process. The original party never responded to you. They have no record against you. Now you're sitting there going, well, why am I not getting a remedy? The reason you're not getting a remedy is you have to have two witnesses to everything. You've got the private record witness to, because they never objected to it in the democracy, which is where they sit and where you submitted it. But you've got no acceptance in terms of acknowledgement of the rule of law upon which you submitted the factual record. So you need a witness in column 2 that they can recognize the law of the jurisdictional venue from which you submitted your factual record. They can only do that on appeal. They cannot do that in the original jurisdiction. So who has to request the appeal? You do. Isn't a creditor proactive or is the creditor reactive? You, sir, are reactively waiting for them to give you a remedy. So you stepped out of character. You didn't do it on purpose because you didn't understand. Now, if a third party inside that corporation or company writes you a letter, what did they just open up? They opened up a channel of negotiations to demand your appellate hearing. See, when the IRS sends you the notice of lien and levy, that is a new communication from some new party within Internal Revenue. Now, Internal Revenue is very easy. They just said, do you want an appeal? Please. But when Martha sends a letter over saying, well, you know, I worked for accounts receivable over here, and you haven't paid anything for 5 months, and we're about ready to turn off your utilities. Oh, thank you, Martha, because I'm going to accept your offer, and I'm going to say, I'm conditionally accepting, Martha, that you have my authority to turn off my utilities for lack of payment on proof of claim that I can't appoint you as the appellate officer in this proceeding, and that I can't send you a copy of the certified record where down below it looks like, according to the record, there should have been set off on this account months ago. Now that I'm appointing you as the appellate officer, I'm sending you a copy of the record on appeal attached to this return. And as the appellate officer, I direct that you review this on appeal as of right. And if your appellate review shows that my record of set-off should be sustained, I want you to direct your company to apply the set-off to this account and to continue my services. Now, since you've just elected Martha as the appellate officer, when you go on appeal, what do you have to do as far as the other party who's in the appeal? You have to send them a copy of the record you submitted on appeal. So you've got to send a copy of a letter to the CFO saying, hello, I just appointed Martha within your organization as the appellate record, since it appears as though there's been no credit on my account, and I'm appealing as of right now the fact that there has been no ledgering of the set-off. Since we're on appeal, I have notified you of the record. Please find attached a copy of the record on appeal. Isn't this the second time you are sending to the CFO all of the information in the record? Now, on appeal, once you have put in the record on appeal and you have requested the appellate court to rule based on your issue of law based on this record, what happens if the other party in the appeal does not put anything into the appellate officer? He's again left the field of battle, right? So what should the appellate officer now do? They should write you back and say, we reviewed your record after carefully investigating everything within our organization. Please forgive us for not having ledgered your account. According to our latest records now, you are current. But you see, the reason you're not getting a remedy is you don't understand it takes 2 or more witnesses. You got to have one from column A and one from column B. We got to agree on the facts, and we got to agree on the issue of law. You've got an agreement on the facts where you're at right now, but you haven't gone on appeal to get a consensus on the law. Now, if you come back and they say, well, your new bill, because we haven't credited your old account, is now $5 billion, and you do an A for V, R for V, and a return, that's not going to solve anything. Because since you have not gotten them to agree to the law of your tender in the past tenders, what makes you think that your new submission is going to get you any remedy? You got to resolve the old matter first. Once you get the old matter resolved, they'll go, okay, this guy is submitting them from the Republic. We got a pattern going here. We'll keep crediting his account. But what you're doing is you're trying to open up a new factual case, and you haven't resolved your first factual trial case. So you're just going to go on forever and ever and ever, opening new cases every other month until they finally just close off your utilities and just ignore you. You've got to understand how to take it to completion. And to go to completion, you need to settle the facts and you need to settle the law. You can only settle the facts on the court of first instance. You've got to settle the law on the court of second instance. The pattern is there. That's what we need to do.
Let me just make sure I have this straight.
What did he say?
I'm going to repeat back what you just said.
Would you rewind the tape and just replay it?
Yeah.
Go ahead, sir.
Video or audio?
Beg your pardon?
Say, get the video or audio.
If you have a question, bring
I just want to
And
reiterate in a nutshell, I think you misunderstood part of my question, which is my fault. But what you're saying is I didn't call to action the CEO when I had the opportunity to call.
No, you didn't. The CEO did not get called to action because he's the trial court and he agreed with your facts. That's as far as he can go. He's waiting for you to see if you understand how to bring a call for action to accept the law of your case. And that's not an issue with the CFO. That's an issue with some other department within their organization. Now, usually when we appoint Martha as the appellate court, Martha will go, oh, no, that's not me. If you've got an issue, then I'll make a note here. You contact Fred. He's the attorney in this office. And we go, excellent. He's now going to be appointed the appellate court.
Okay, I think I got misunderstood again on my part. I have been interacting with the CFO, and I got a letter from the CEO.
And what did the letter from the CEO say?
You haven't been paying your bill. Is there a problem? Which I
said, the CEO is now Martha. He's an imposter. He's an intervener.
Precisely, which I conditionally accepted that.
Appoint the CEO as the appellate officer. That's what we just said.
That's what I was asking, to make sure I had that clear. So that's what I
Whoever
missed in this process.
interferes can be the appellate officer unless they come back with a counteroffer that says, oh, no, that's not my job. If you want to do that, go to this department or this person. They're just telling you where to send your appeal to. So do they understand we have a right of appeal? You better believe it, because notice and opportunity is imperative in due process. And I'm just telling you, you don't understand the process. You think when you're done with the fact-finding, you ought to get a remedy. And I'm saying you're not gonna.
That's what you're saying what I missed in this whole thing is you're now saying what I didn't do is appoint the CEO as the appellate.
Correct.
Gotcha. Thank you.
Okay.
Then, Now I'm still receiving unsigned offers. My question is, do I continue responding to any of those, or do I
How
pretend
long ago was the CEO letter in your receipt? A day, a month, a year?
A month.
A month? Your whole process, including the appeal, should be wound up within 90 days. If it isn't, your tender offer may go stale.
Okay, I can still do that with
Okay.
what information you just gave me.
Very good. See, did you respond to the CEO letter?
The first, yes, I did.
What did you say to him?
I conditionally accept your offer.
Wrong. That's why you're getting the communication from accounts payable. Because you went back on a new fact-finding contract, you abandoned the field on your claim. Since you abandoned the field on your claim, you have no claim, so you're a debtor, so they're still trying to collect from you on the public side. Nobody did anything wrong in that corporation. You did something wrong when you sent the wrong message back to the CEO.
Did you include a copy of the record you had of the CFO to the CEO?
Yes, I did.
Did you ask for an appeal? No, you did an A for V, R for V. You didn't ask for an
he
appeal.
didn't say he did an A for V, R for V.
I've only done one A for V, R for
Right,
V, the
right.
original.
You did a conditional acceptance, and you brought the record into your conditional acceptance.
Correct.
So is that not an appeal?
But a conditional acceptance.
Right. No,
he's
he didn't.
saying,
He's just missing the appointment
Yeah,
of
but
an appeal board or the
hang on,
request for an
Brandon.
appeal board.
The CEO said, please pay your account. And he's doing a conditional, okay, I'll repay the account.
On proof of claim that it wasn't already paid based on the record and pleadings of the parties submitted.
I understand, but why are you going to get a contract with him, a contract with them, and a contract? This isn't about contracts. We already had the agreement with the CFO, which is the contract, and what we got to do is perfect that contract, not create more public contracts with this entity. And that contract with the CEO is a public contract. So you've taken your private settlement out of the jurisdictional venue of the private. Now what's the law of the case? Isn't it moved over to the public? Because you did a conditional acceptance with the CEO. What jurisdiction is the CEO in? Private or public?
Public.
So now you said, okay, I tried a private contract settlement. Now, in place of that, I'm going to do a public contract settlement. You just moved the law of the case. You should have stayed with the private contract settlement and appointed him as the appellate officer so that the private law of the private settlement contract becomes the law based on the appeal. But now you move from private contract to public contract, and as soon as you did that conditionally, you said, I'll just do everything you say on proof of claim that. Okay, but you're contracting on the public side.
What do you suggest at this point then?
Nunc pro tunc, come back and appoint the CEO as the appellate officer based on your original, with the original record with the CFO. See where that goes. Nunc pro tunc it back into time.
Thank you.
Okay? Everybody understand why we go on appeal?
That's what I think.
Okay.
Just continuing his line of questioning, if he never spoke to the CEO, but he just got a letter from accounts receivable and Martha didn't sign it, then what? You can't appoint somebody that didn't sign anything. You can just send a record to them, but you can't do anything else. Can you?
But the CEO at least had his title on there.
In this case, but I'm
That's
changing
correct.
it. If it's a different case, if he never got anything from the CEO, instead he just got something from accounts receivable.
Okay, sometimes there's email. Is there going to be an email address there? For a
Very
return?
often
You
there
better
is
believe
nothing.
it. Sometimes it's a telephone call.
Okay.
Are you talking to a person? What is your name?
If there is no name, that's my
On
question.
a telephone call, I better know who I'm talking to.
Obviously,
If you
but
won't give me a name, I'm not going to speak with you.
But it's a letter and there is no name. A letter, no name. You just have to send the pleading, and that you cannot appoint anybody for anything.
Then what you do is you do a conditional acceptance on the letter predicated upon the proof of claim that am I not entitled to an appellate proceeding? And I will conditionally accept anything you're telling me as long as first you inform me of who the appellate proceedings is within your corporation, or else just give the company a call and say, hey, I have a dispute here on a payment. The factual record is pretty well established. What is your appellate claims department, or who do I contact to go on appeal? They'll give you a name or a number.
You're still going to send all the record you have so far?
You send the record between you and the CFO as your record on appeal. And then when you send it into the appellate department, you're going to send a copy and notice of this to the CFO, because he is the other party in the appeal. He has to have notice and opportunity to respond at the appellate hearing. But do you think he's going to?
No.
No. But that's immaterial and irrelevant. See, they never charge their brother. If you're doing it right, which means you're on the Republic side, why would anybody charge your brother on the Republic side? You wouldn't do it because you don't want them to charge you. And so the CFO doesn't charge you with anything wrong. You don't charge him with anything wrong.
I still need to send all the record to accounts receivable to the unnamed person that sent it, right?
You need to respond to whoever writes to you. So if you get an unsigned letter from the accounts receivable department there, what you do is you do a conditional acceptance to them on proof of claim that upon appeal and the decision of the appellate department within their organization, that this matter should not be set off, zeroed, and closed. So you can send to them a copy of the appellate record you're sending to the appellate department, which is the same record you're sending to the CFO to let him know you're on appeal. Now, you have not failed to respond to the collection letter, so you're not in dishonor there, but you're basically saying, you people need to do a timeout. Here's a copy of my appellate proceedings. You should abate any action until the appellate decision comes down.
All right. No. Stop.
I understand, Jack. I got a question for you to start with afterwards.
Okay.
You've been sanctioned.
I have. They have been sanctioned. Okay. We're at 6 o'clock. We're going to take a 2-hour dinner break and be back here at 8 o'clock.